May it please your lordship. Lordship, I beg to mention item number 30 to 34, your lordship.
Just a minute.
For hearing, your lordship.
Oh, pencil is here, na? Which
Item
item?
30 to 34
Yes.
for hearing, your lordship.
Mm.
Lordship, in the last interim, your lordship,
Mm.
direction was given to file an affidavit, your lordship. With regard to annexing the DPR and the relevant documents, your lordship.
Okay.
Lordship, affidavit is already prepared, your lordship, but signature is yet to be appended, your lordship.
Okay.
If 2 weeks time be given, your lordship.
2 weeks.
Your lordship.
You're for the petitioner
Your lordship, for the respondent, your lordship.
or respondent? Who?
Lordship, I am for the petitioner.
Any objection?
No objection.
All right. As paid for by the learned counsel for the respondent.
6, your lordship.
Respondent number 6. Further 2 weeks time is granted for filing affidavit.
Yes, your lordship.
Additional affidavit.
Yes, your lordship, additional.
List again after 2 weeks.
Much appreciated.
Yes.
Lordship, I beg to mention item number 7 and 8. Lordship, here the cabinet they have given its approval last week for regularization of the petitioners. I pray that this matter may be listed after 3 weeks, Lordship.
Why 2 weeks?
So that to bring out the compliance of the Lordship. Yes.
You were supposed to take instructions.
Yes,
Isn't
so the cabinet they had already given its approval last week. So
Oh.
after the approval was given to Lordship, then only the regularization order will be out.
Cabinet has given approval.
Yes, last week. only.
Can I record?
Yes, Lordship.
Okay. Miss
We should.
V. Shukre, learned additional AG, preparing for the respondents, submits that the cabinet has given its approval last week, and therefore the matter may be adjourned for 3 weeks for compliance of the court's direction. Prayers allowed. List again after 3 weeks.
Much obliged.
7 and 8.
Once again, welcome to Kohima, and on behalf of the bar, I would like to wish the Happy New Year to you.
Thank you. Same to you all. Thank you.
Lordship, I beg to
Yes.
mention item 37 to 45, Your Lordship. I have taken the consent of the petitioner, Your Lordship. This matter may kindly be listed after 2 weeks, Your Lordship.
What are these
On behalf of
matters?
the state,
What are them? What are these matters?
These are the petitioner seeking for minimum scale, Your Lordship.
Okay.
Minimum scale of the, Your Lordship.
You're for the state
Yes, Your
respondent.
Lordship.
Anyone for the petitioner? Have you taken consent?
I've taken the consent, Your Lordship.
Your good name, please.
In Naholi, Your Lordship.
Your government advocate.
Yes, Your Lordship.
Ms. Inaholi, learned government advocate, appearing for the state respondent, submits that the matter may be adjourned for
After 2 weeks, Your Lordship.
2 weeks, as she has some personal difficulties. She submits that she has taken the consent of the other side to stop in view of above. And has paid for this again after 2 weeks.
Your Lordship, I also make to mention item 47 to 51, Your Lordship, on behalf of my colleague K. Angami, Your Lordship. He is indisposed today, Your Lordship, and he has taken the consent of the petitioner, so this may kindly be fixed on 13 to 24, Your Lordship.
What are these matters?
Your Lordship, I'm not aware, I'm mentioning on behalf of my colleague, Your Lordship.
Mr. K. Angami, learned senior government advocate,
Senior government advocate, Your Lordship.
is reported to be indisposed. Stop on a mention made on his behalf and not objected to by the other side. List the matter again on 13th,
13, Your Lordship.
13th of February.
Much obliged.
Much pleasure.
Wait, please, my lord. Lordship, I beg to mention item number 51. We are appearing for the respondent number 5, so allow us to 3 weeks to file our affidavit in opposition.
No, 51 just, we have passed the order, isn't it? 51, it's clubbed
51,
together with
yes.
47. 47 to 51 are clubbed together.
Yes, Your Lordship.
No, Lordship, this is different one.
Huh? Which one is your case? Case number?
20.
You have a different cost list now.
Lordship, there is a little bit confusion with. Yes, Lordship, this is another one.
No, you just tell him the case number, party's name, we'll see. Which one?
Mine is. 5th. Mine is also 5th February 2024, Lordship, and I have another till.
No, you tell me your case number. What is your case number?
166.
166. Item 51 is not 166.
Item 18, Your Lordship.
Here it is listed at item number 18, Lordship.
Correct. So 18, this is your case.
Yes, Lordship.
And what do you want?
Grant us 3 weeks to file affidavit in opposition to the writ petition. We are for respondent number 5, private respondent.
On the prayer of Ms. Z. Zimomi, learned counsel for respondent number 5, 3 weeks time is granted for filing counter affidavit. List again after 3 weeks.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 46, Your Lordship.
Yes.
On behalf of P. Sharon, Your Lordship, for respondent number 4 to 7, Your Lordship.
Okay.
Lordship, here, leading counsel is indisposed of, Your Lordship. If the matter can be posted after 3 weeks, Your Lordship.
Private respondent.
Private response, Your Lordship. 4 to 7,
When do you want it? After?
3 weeks, Your Lordship.
No objection, Lordship. No objection. Okay, Mr. P. Suren, learned counsel for the private respondent, is reported to be indisposed. On a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for 3 weeks. List again after 3 weeks.
Much obliged.
Yes.
My blessed Lordship, I beg to mention item number 21. I will receive instructions, so kindly grant me 3 weeks time.
Your good name?
Bichano. Bichano,
Ms. P. Chano, learned government advocate,
Lordship.
appearing for the state respondent, submits that received the instructions and she may be granted for the 2 weeks' time for filing counter affidavit. Praise the Lord. List again after 2 weeks.
Lordship, a similar prayer with item number 22.
Same order, similar order in 22.
And Lordship, I also beg to mention item number 15 on behalf of Liviga.
Yes. What do you want? What do you want?
Lordship, may kindly grant 3 weeks time to file affidavit.
Okay. On a prayer made on his behalf of Miss Livika, learned government advocate, appearing for the state respondents, for the 3 weeks' time is granted for filing counter affidavit. List again
Lordship,
after 3 weeks.
similar prayer with item number 16 and 17.
This is also Livika.
Lordship,
Okay, same order, similar order in 16 and 17. Yes.
Lordship, I also like to beg to mention hearing item number 27 to 28
You're gonna finish the entire list.
on behalf
Huh?
of Tipa. 27 to
29.
29, Lordship.
Tiba, what happened to Tiba?
Lordship, he has some personal difficulties.
He is for the, he's appearing for whom? Tiba,
State.
have you informed the other side? Any
My lord.
objection? Any objection?
My lord, the council is not present.
Okay. A mention has been made on behalf of Mr. E. Thibapom, learned government counsel, to the effect that he has some personal difficulties to appear before the court today. And therefore, the matter may be listed again after
2 weeks.
2 weeks. To stop the said prayers not objected to by the learned counsels appearing for the opposite party. Next, para in view of above, list again after 2 weeks.
Lordship, I also like to beg to mention item number 24 on behalf of Tipa.
You're mentioning wholesale. Huh?
He's yet to receive instructions, so kindly grant 3 weeks time. to file
Item
affidavit.
24.
Lordship,
No, 24, let's see, we'll take up the matter. It appears that respondent number 7 is not served. We'll pass necessary orders when the matter is solved, okay?
the state is yet to receive instruction, Lordship.
Yes, we'll grant you time,
Lordship,
no problem.
Lordship.
Yes,
Mr. Lordship,
yes.
Your Lordship, item number 9, Your Lordship, here the pleadings are complete. So this may kindly be listed for hearing in the usual course, Your Lordship. Item number 9.
What about the other side?
Lordship, no objection.
Okay, parties submit that pleadings are complete and the matter may be listed for admission hearing after
2 weeks.
2
Your
weeks?
Lordship. In the hearing list, Your Lordship.
Stop. Next para in view of above, issue rule returnable by 2 weeks. Since the parties are represented, no formal notice is required. This is the matter for hearing after 2 weeks.
Much obliged. Your Lordship, I also beg to mention item number 19, Your Lordship. I'm making a prayer on behalf of Kiangami, Your Lordship. Here, he's seeking further instructions. So this may be listed after 3 weeks, Your
State.
Lordship. Item number 19.
And Kiangam is for state.
Yes.
He's for the
Yes.
state respondent.
Yes, Your Lordship.
Okay, on a prayer made on behalf of Mr. K. Angami, Learned State Council, appearing for the state respondents, further 2 weeks' time is granted for filing counter affidavit.
3 weeks, Your Lordship.
Okay, 3 weeks.
Yeah,
List
there
again
is-
after 3 weeks.
Much obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention order item number 26. Here notice upon respondent number 5 and 6 are still awaited. So kindly grant me 2 weeks' time.
We'll pass the orders when the matter reaches. All right.
Yeah, to the Lordship. Lordship, I beg to mention hearing item number 35, Lordship, on behalf of additional AG in Team Song, Lordship. Lordship, if this matter can come up after 2 weeks, Lordship.
On behalf of whom?
In Team Song, additional AG.
Have you informed the other side?
No, Lordship.
A mention has been made on behalf of Mr. Im Song, Learned Additional AG, to the effect that he has some personal difficulties to appear before the court today. And therefore, the matter may be adjourned for 2 weeks. Stop. Opposite party is not present, but Mr. Your name? V. Zimomi, Learned State Council, undertakes to inform the Learned Council for the opposite party. Next, para in view of above, list the matter again after 2 weeks.
Lordship. I know.
Please, Your Lordship, I beg to mention item number 36, hearing item number
36.
36 Kindly grant us 2 weeks' time to file affidavit in reply to the opposition filed by respondent 6.
Okay, although the matter is listed for hearing, the learned counsel, please write. Although the matter is listed for hearing, the learned counsel for the petitioner seeks time for filing rejoinder affidavit. Prayers allowed. List the matter again after 2 weeks.
Yes, sir.
Let rejoinder affidavit be filed in the meantime.
Much obliged.
Bless your lordship.
Yes.
Lordship, I'd like to mention item 12.
Hmm.
Your lordship, let this matter become up after 3 weeks.
Why?
Because,
You are to inform the court about the latest status.
yes.
What is the
initiative
instruction?
is going on, and I'm seeking the
Huh?
steps taken, I'm seeking the steps taken by the state.
Oh. Your good name? Your good name, please?
No, I mentioned,
Moim Chand. You are for which respondent?
I am for respondent number 4. That is the assistant.
12. You are there for,
Your lordship, I'm for the petitioner, your lordship.
you want some time.
Lordship.
Mr. Moim Chand, learned counsel appearing for respondent number 4. Submits that he is yet to receive the up-to-date instructions and therefore 3 weeks time may be granted for the purpose. Prayers allowed. List again after 3 weeks.
Lordship, much obliged.
May I please, your lordship, I beg to mention item number 19. Kindly this matter may be listed after 2 weeks.
19. You are for the,
I am for the petitioner, your lordship.
anyway, counter is not yet filed, na?
Yes, your lordship.
On the prayer made on behalf of the parties, matter stands adjourned for 2 weeks. Stop the state respondents to file their counter affidavit in the meantime.
Your lordship, there is an interim.
Item 19, isn't it?
Yes, your lordship.
Did I pass? I think we have passed the order already.
Lordship, I've sought for 3 weeks' time, your lordship, to file
Ah.
counter, your lordship, on behalf of K. Angami.
Oh,
Oh,
it's already
okay.
mentioned. There's an interim order. Please write interim order, if any, shall continue till the next date of listing.
Much obliged.
Yes.
Yes, lordship, beg to mention item number DD on behalf of Sipung Chang.
On behalf of
Sipung Chang.
government advocate,
Lordship.
what do you
Lordship,
want?
we kindly grant 3 weeks time to file affidavit.
Okay. Mention has been made on behalf of Mr.
Sipung Chang.
Sipung Chang, Learned State Council, to the effect that for the 3 weeks time may be granted for filing counter affidavit. Prayers allowed. List the matter again after 3 weeks. Respondents to file their counter affidavit in the meantime. Yes.
Much obliged.
For motion, item number 1.
Yes.
In this IA, I'm seeking a small protection from. The state has given up to the 31st of December for retention of the quarter that have been allotted to me during my service.
Today is 5th of February.
Yes, Lordship.
You are still there.
I'm still there.
Why?
Lordship.
You're supposed to
the authority
vacate in the
also
new
has
year.
nothing to order,
You're
evicting
supposed
me.
to vacate in the new year. Why are you still there?
Lordship, the authority also has not taken any steps to.
You are-
get me further.
I think you are permitting to stay.
No, Lordship, in fact, I'm trying to get in contact with the department, Lordship.
Ah.
However, till such time, Lordship, I'm yet to receive proper instruction from the department itself, Lordship. So if Lordship may please to list the matter day after tomorrow, Lordship, so that I will get a proper instruction. And will
Yes.
list-
Lordship, that's fine, but status quo on the day may be passed.
Yes. On the prayer of the State Council, list again day after tomorrow.
Lordship,
Status quo be maintained as on date.
yes, Lordship.
DB, na? We'll have it on Thursday. List the matter on Thursday,
Lordship.
as prayed for by the Learned State Council. Stop. In the meantime, status quo as on today shall be maintained by the parties.
Yes, Lord. For motion, item number 2.
Yes.
Your Lordship.
Huh.
Your Lordship, here all the petitioners, that is petitioners number 1 to 106 are work charge employees, my lord,
Okay.
under the Department of PHED Kohima, Nagaland, your Lordship.
Hmm.
Now, your Lordship, the petitioner being eligible for regularization of service as per the Office Memorandum 2015,
Hmm.
the department has forwarded the details of the petitioners via different office orders
Hmm.
for early finalization of proposal for regularization of service to the government, your Lordship. But your Lordship, till date, nothing has been done, your Lordship. So for that matter, the petitioner through the council has submitted legal notice, my lord, for regularization of their service as per the Office Memorandum 2015, my lord.
Where is that page? Page number?
Page number 103, Annex 213, your Lordship. This is the legal notice, your Lord.
Legal notice. Why
Yes, your
did you
Lordship.
serve legal notice?
Your Lordship, since they are
You're not-
eligible,
are you
your
going
Lordship.
to- are
Now,
you-
my lord,
Are you
after
planning to
the
file a suit?
Lordship, now, your Lordship,
Uh-huh.
after this legal notice was issued, your Lordship, the department has
Has what? They want to terminate your service now.
yes, your Lordship,
Ah.
I'll take your Lordship to
You should have given a representation.
page number 110.
Read, please read.
The department has via this office letter has replied that to our legal notice, your Lordship, Office of the Chief Engineer, Public Health Engineering Department, Nagaland, Kohima, office letter dated November
Madam, I've
2023,
read
your
it.
Lordship. Your
They are,
Lordship.
they're asking the details of your clients. Have you given the details of your
Yes,
clients?
your Lordship, details has already been provided, your
When,
Lordship.
when? An extra 15.
Yes, your Lordship, an extra 50. This is the reply, your Lordship.
Then,
And your Lordship, it has
There
not
are-
been attended to till date. So therefore, being aggrieved, the petitioners are here before your Lordship.
your good name?
Aratsla Kips.
Art Miss R. Atsla Keps, Learned Counsel for the petitioners who submits that by filing this writ petition, the petitioners pray for regularization of their services. As per Office Memorandum dated 17/3/2015. Stop. She submits that the petitioners are working as work charge employees under the State Public Health Engineering Department and are covered by the state notification. To stop, she submits that although the petitioners have approached the respondent authorities, the state respondents having failed to take any positive steps, the petitioners are before this court. Stop, the Learned Counsel has drawn the attention of this court to the legal notice served by the petitioners on 7/11/2023, the reply given by the department on, what is the date? An extra 14?
Reply dated 30/11/2023.
30/11/2023. And the submission of details of the petitioners
11/12/2023.
How do you say that? There's no date?
Page number 114, last page, your Lordship. Date is 11/12/2023. The last page.
Submitted by the petitioners on 11/12/2023.
Yes.
December, 11/12. Stop. Next para, in view of above, issue notice of motion returnable by 4 weeks. Miss So-and-so, Learned State Council accepts notice on behalf of all the respondents.
Yes, your Lordship.
As such, no formal notice is required. Petitioners to furnish requisite extra copies of the writ petition, if not already done. List again after 4 weeks. Pendency of this writ petition shall not debar the respondents from considering the grievances of the petitioner as represented by them and as indicated herein above.
Obliged, my lord.
Yes.
For motion, item number 3.
May it please, my lord, lordship, the petitioner is the landowner of the executive engineer PWD R&B Atoizi Division, Zneboto Office, lordship. In 1984, by oral agreement, the Chopik lands donated plot of land for establishment of the EE office at Atoizi, lordship. Even in the first instance, lordship, the respondent through political backup kept on appointing the grade 4 posts, landowner posts, other non-landowners. So it was way back in 1986. Lordship will kindly see at Annexure A, page 12. They submitted the landowners type out copy is at 12A, Lordship. Complaint for the post of grade 4 staff. This was submitted by the petitioner's grandfather in the year 1986 to the chief engineer PWD Kohima, Nagaland. Then, even after that, lordship, lordship will kindly see that annexure A2, page 13. This is the head DB, that is Debashish, that are customary law customary law judges, Debashish, lordship. Head Debashi ESC office Atoizi has, lordship, has issued a certificate stating that Nitovi Chopi is the landowner. He is the father of the petitioner's father. Then my lord will kindly come to page 22, E1. This is the office of the additional deputy commissioner Atoizi. The district administration certificate is a must for the landowners as per the government's instruction, lordship. So this is the landowner certifying that the petitioner is the son of Sri Vitoi Chopi, Vekoho, all village, is one of the landowners of PWD R&B Atoizi subdivision. Hence, there is no objection for claiming grade 4 post at PWD R&B office Atoizi. Lordship, there is a landowner scheme for the landowners, lordship, and my lord will kindly come to village council has also certified that at annexure B317.
Okay, see, you claim that you are the land donor.
Yes, lordship.
Then who is this respondent number 5?
So instead of considering my case, they have appointed another person.
He's also landowner.
No, lordship. He's not a landowner. So I'm challenging his appointment order, and I'm praying before the Honorable Court for a direction for appointment on landowner basis as per the scheme.
Where is the appointment order of this respondent number 5?
Lordship will kindly come to page 18, annexure C. This is 13 January 2023. May I read out, lordship? Consequent upon the approval of the government by the letter number so and so dated 4/1/2023, Sri Otoka Aye, age 34 years, date of birth 8/3/1988, educational qualification graduate, son of Tolvi Aye of Atoizi Towns in Zneboto district, Nagaland, is hereby appointed as peon under the executive engineer PWD R&B Atoizi.
Okay. Ms.
Yes.
Zimomi will issue notice. of this case.
Lordship,
All right.
I'm
Art-
challenging this.
Art Ms. Zimomi, learned counsel, Z Zimomi, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the appointment of the respondent number 5 as grade 4 in the establishment of the engineer in chief NPWD Nagaland Kohima
Without advertisement, lordship.
without advertisement and through backdoor entry. Provide office order dated 13/1/2023. To stop, the learned counsel submits that the petitioner in fact belongs to the clan who are the land donors of the existing office of the executive engineer, PWD
PWD RNB.
Atoizu Division, PWD within bracket RNB, Atoizu Division, Zunebuto. Next, para in view of above, issue notice of motion returnable by 4 weeks. Miss Picha Lokita, Learned State Council, appears and accepts notice on behalf of respondent numbers 1, 2, 3, and 4.
1 to 4.
1, 2, 3, and 4. As such, no formal notice is required. Petitioner to serve requisite extra copies of the writ petition to the learned government advocate, if not already done. Petitioner shall take steps for service of notice upon the respondent number 5 by registered post with ADU within 3 days.
Lordship.
Just again after 4 weeks.
Lordship, in the meantime, subject, the appointment of the
Appointment of
respondent.
respondent number 5 shall be subject to the outcome of the writ petition.
Obliged, Lordship.
For motion, item number 4.
The Lordship, by order 8/10/8/2023. State respondents were directed to release less drawn salary to the petitioners. Now the process is going on, identifying those who are entitled. And the total amount come to 2.2 crore something. So the Lordship, I'm seeking 3 weeks, 3 months more time for the payment.
Release of what? Area pay?
Your Lordship,
Release of what? What was the direction?
to complete the process for payment of less drawn areas to the petitioners within the period of 4
To complete the process of payment of areas.
areas, yes, less drawn areas. Lordship, you will find
What do you mean by less drawn areas? Means
less drawn areas means, Lordship,
they did not
Yes.
receive their entitlement.
yes,
They received less.
yes,
Okay.
they are entitled. State has admitted that they are entitled. Now, only the process,
Okay, and you want some more time?
3 months more time, Your Lordship.
Okay, and this,
Maybe, Mr. Lordship. Your Lordship, I have received the copy only this morning and I need to take some instructions from my client. So if it may be listed again on Thursday, Your Lordship.
okay, list again on Thursday, as paid for by the Right Council for the writ petitioner.
Much obliged.
Stroke respondents.
Obliged.
Yes.
For motion, item number 5.
May I please, Lordship?
Yes.
Lordship, this matter pertains to regularization of work third service for the purpose of pension and pensionary benefits. My Lord, the petitioner was initially appointed as work church skilled employee, and thereafter he was promoted to the post of Khalasi on 14/4/1989, granting him scale of pay. Lordship, the petitioner has been rendering continuous service for the last 34 years. And is still in service. Lordship, the petitioner is also represented to the department on 11/3/2003, as well as after having served for 16 years of service, he has all met in application. My Lord. Lordship, there is a scheme 2022/9/2004 and OM 17 March 2015, which squarely covers the case of the petitioner. My Lord.
What does it say?
As per
The
OM
scheme.
2004, it is required that he must be a work church employee, and it is a 2004 OM is a policy scheme for regularization of work church employees. My Lord. And as per this OM, 50% of all work church employees must be well, not work church employees, but 50% of all regular vacancies arising in the department are to be reserved for regularization of work church employees. My Lord. And the remaining 50% to be are to be filled up as per the normal rules of recruitment, my lord. And as per the OM 2015, it is a policy and scheme for regularization and absorption of workers, employees and casual employees, and also for revision of pay wages, my lord. And as per this OM, it is lordship, the OM 2015 is in page number 22, my lord.
And what about the other one?
In
22/9/2004,
2004 is in page number 20, my lord.
20.
And as per 2015, all existing workers employees as well as casual employees in various departments, they who are enjoying scale of pay, my lord. Lordship, the petitioner here is also enjoying scale of pay, and also who have completed 30 years of continuous service. And the
30.
petitioners, lordship,
30 years.
yes, my lord.
You have completed 30 years,
34 years, my lord.
34 years.
Yes, my lord. And the petitioner is also on the verge of retirement, my lord. And as per this OM, lordship, you'll find it in the succeeding para.
Okay, we'll examine. The government advocate, anything to submit at this stage? All right, your good name?
Mane Koja, my lord.
Art, Mr. So-and-so. Where is your name in the court list?
Lordship is,
Not reflected?
yes, my lord.
Not there?
Lordship, it is in the fifth list, fifth one.
Okay. Manhe,
Yes, my lord.
Art, Mr. Manhe Konyak, learned counsel for the petitioner who submits that by filing this writ petition, the petitioner seeks regularization of his service in terms of the office memorandum dated 22/9/2004 and 17/3/2015. To stop, the learned counsel submits that the petitioner is a work charge employee and has been serving as such for the last 34 years. To stop, he further submits that the petitioner is also receiving scale of pay, and therefore he is covered by the said notifications. To stop, the petitioner is now on the verge of retirement, and therefore the petitioner seeks for a direction for regularization of his service. Next para, in view of above, issue notice of motion returnable by 4 weeks. Miss So-and-so, learned state counsel, appears and accepts notice on behalf of this. All the respondents. Extra copies of the writ petition be furnished to her if not already done. List the matter again after 4 weeks.
Much obliged.
Duly obliged.
For admission, item number 6.
Yes.
May I please lordship?
Hmm.
Not here, there is no deliberate disobedience of these honorable courts passed in Resolution number 21 of 2020, my lord. The petitioner's father expired on 28/10/2016. After the expiry of the petitioner's father, I'll just give you a brief gist of this background of the case, my lord.
You are for the petitioner?
I'm for the contemners, my lord.
Huh?
I'm for the contemners, for the respondents, my lord.
Okay.
Just I want to highlight the brief background about the case. So after the expiry of the petitioner's father, the petitioner have applied for compassionate appointment. Since his case was not considered, he approached this honorable court by filing WBC number 21 of 2020, which this honorable court has disposed of the writ petition by order 14/2/2020, directing the respondents to consider his case for appointment within 2 months.
Mr. Counsel.
Yes, my lord.
I appreciate your explanation, but I have read the last order already.
Yes, my lord.
So what is your instruction today?
So, my lord, the department has come up with the fresh list wherein the name of the petitioner is at serial number 1. So the petitioners, the recruitment process is to be initiated very soon.
Very soon means when?
Exact date, my lord. Because the appointment was banned after the pandemic, but now it's open. So it will be circulated very soon. So as and when the recruitment process is initiated, his case will be considered for appointment. Since his name is at seal number 1.
No, I understand, but as and when, we don't know, no, when will happen, when will it happen? As and when means it can be after 1 year
But-
also.
well, it will be-
Exactly, Lordship.
It is going to be advertised very soon, and then
But what has it got to do with the advertisement? Since
No.
this is a
well,
compassionate
once the
appointment.
recruitment process is initiated, reservation will be kept for commissioned appointees.
No, you please inform the court, when are you going to do the
My lord,
taking the
in-
steps?
That's why, my lord, since now the petitioner's name is at seal number 1,
They kept it at serial number 66.
no, as per the new list, his name is at seal number 1. So, my lord, exact date, my lord, for that, I have to take the instructions, so I may be given a week's time so that I can give you the exact date when, but exact date is the recruitment process is just at the, it's under process, my lord.
Your good name, your good name?
N. Longkumar, my lord.
Mr. N. Longkumar,
Yes, my lord.
learned counsel for the respondents. Which respondent? All of them?
Yes, for contenders number 1 and 2.
For the respondent numbers 1 and 2, submits that he may be given a week's time to get instructions as to when the recruitment process is going to start. Prayers allowed, list again after a week. Beginning part, you write first, peruse the order dated 7/12/2023. Okay, then next paragraph, continue that.
Obliged, Lordship.
For admission, item number 10.
My lord, the present petition is for illegal recovery order. My lord, I may be allowed to take your lordship to the issues that the petitioner represented. Earlier, he was discharged by a authority who is not legal. So that part of the discharge was quashed and set aside by this honorable court. Then, for the period of discharge, illegal discharge, he treated it as there is none, not entitled for anything. So the petitioner approached this court by filing a writ petition, which was allowed. In the Union of India, we have taken up in writ appeal. And in the writ appeal, it was, the word is question set aside, but the division bench clearly have given that as per the principle laid down by the Supreme Court, that has to be considered. Instead of that, what we've done is we've taken the decision not to pay the pay-in allowances for that particular period. However, since he was entitled for the 6th pay commission, no, revised pay taxation in terms of 7th pay commission, that is with effect from 1/1/2006, be extended in errors therapy made to him. What happened? That calculation came to some 12 lakhs 93 something. So what happened? Later on, again, the illegally decided to terminate discharge it, but it for that period, this time, he was granted pension in service benefits. After the dismissal, discharge, what happened is that when the account was settled, that amount of rupees 12 lakh something, which was paid as 7B commission, starting from 1st January 2006. He tried to recover it. In the process, what happened is that annexure it deducted the petitioner's gratuity amounting to 4 lakh something. Page 38 of my petition. Leave encashment of rupees 2 lakh something. Total entitled amount of rupees 7 lakhs something. You are saying that I have to pay them another 5 lakhs something. My lord, in my writ petition, I was under impression that I was paid the pay and allowances for the discharge, illegal discharge period. So in my petition also, page 5, writ petition, I made that statement. So para 3.4, in compliance with the Honorable Appellate Court order passed in such and such, the DGER speaking order 13 December 2009, Annexure 6, decision is this. Now, therefore, it has been decided by the respondent authority to treat the said intervening period from the period is 15/5/2010 to 19/9/2015 as is pensionable service.
What is this period? This is the period wherein it was treated as Dyson.
Yes, my lord.
Okay.
Yes,
So pensionable service.
that is what. The notional pay fixation benefits would be extended to number such and such for the intervening period. Pay fixation, it goes without saying. Hence, his pay after reinstatement into service with effect from 29/2015 be refixed notionally. In errors, if any be processed for making payment to him, process for revised pay fixation in terms of 7 CPC with effect from 1/1. This is 2006 as per the decision. Be also extended in error if any be be paid to him. After that extra, accordingly the petitioner's back wages were paid. That is the inadvertent statement made by me. Because that particular period, no pay was allowed. It was only notional refixation. So this taking order, Annexure 6 of my writ petition, page 32, is on the basis of this Honorable Court Division Bench order. So the petitioner as well as me, we were under impression that illegal discharge period, pay and allowances were paid to me. However, after filing up the writ petition, my lord, the respondent came up with the affidavit in opposition. My lord, this speaking order, Annexure 6, which starts from page 32, in compliance with the order dated 29/5/2019, passed by the DB Division Bench, Gauhati High Court.
Mr. Imti Longchar,
Yes,
let us start again from the beginning.
my lord.
See, what was the penalty given to you? Why did you come, why did you file writ petition?
Earlier,
Yes.
earlier, the commandant is not competent enough to dismiss a undisciplined ground constable. It is the IGB, IGAR. So on that basis,
Lordship, sorry for interruption, Lordship.
No.
There is also another writ petition pending. Same prisoner with regard to this discharge from service.
Another writ petition.
Yes, there is another.
Yes. How is it connected with this? Is there any connection with this case?
no,
Because the first writ petition was challenged because it was discharged. Yes, illegally it was discharged.
What,
by
which one is the
commandant.
first writ petition? 17. First writ petition is 17K. Page 19. Page 19.
first discharge is WBC 3K of 2015.
3K.
Yes.
Have you annexed that order?
Yes, yes.
3K. Okay. You initially you filed 3K.
Yes.
Okay.
The illegal discharge was set aside by this court. Thank you. It was not done. Soon it was reinstated.
Just a minute.
That is annexure 2, page 13. It's a short, if I'm allowed to read up.
Just a minute. It's okay. 15/5/2010 is the impugn order. Discharging you.
Yes. Fifteen five. 2010.
You were directed to be reinstated. But the respondents were given liberty to pass appropriate orders
Mellow.
regarding back wages and all that.
Yes.
So what was the order passed?
The operative portion is at page 17.
I've read it. Pursuant to page 17, what did you do? Government or
After
Union of
the
India?
after this writ petition was this was solved, the petitioner was reinstated in service.
Yes.
Mellow.
However, the like wishes that is come 15
15/5/2010 to 19/9/2015.
was considered as no pay.
That's
no-
none. 15/5/2010 to
19/9/2015.
that is the date of your discharge up to your reinstatement. is it?
Mellow,
Yes,
the
Lordship. Yes.
page,
This was treated as what? Dies none.
Nice, none, yes.
Okay, therefore you file the writ petition, the
Malo.
second one.
Mellow.
Hmm.
So that since this honorable court give a order, leave it to the respondent to issue appropriate order if so advised. So page 18 was issued. Where it is taken as page
Then-
15.
No, that's okay. Then 18 is what? Dies none.
My lord, reference such and such. Right side. Dated 5th December 2015 be treated as cancelled.
Okay, I've got it. Now,
This order, the petitioner do not deny. It appears that they have taken the decision as per the law, but it appears they have taken it as a cancel. In republished as under the number such and such, physically reported to this unit on 19 September 2015 afternoon. In reinstated into service with effect from 20 September 15 forenoon. In TOS with effect same day. C, the total absence period is 5 years, such and such. 4 days with effect from 15 May 2010 to 19 September 2015. Has been treated as bias non, period as individual has not done any bona fide duties during the period. Yes,
it's okay. See,
this.
Mr. MT,
Yes.
let us proceed. Now you filed the second writ petition and court directed that you should be paid the pay and allowances.
My lord.
Then the Union of India went in appeal before the division bench.
Yes.
Then that is at page 24. Now, division bench, what was the direction?
My lord, I'm allowed to read out page 27.
Just show me the page.
Paragraph.
29. Just show me the page. Just show me the relevant page. You show me the relevant page.
11 pages, page 27, paragraph. This honorable appellate court has called out certain condition on the basis of the Supreme Court decision. Where it is given page 28. The proposition called out by the apex court are reproduced in the proposition which can be called out from the judgment of the Supreme Court while deciding the issue of back wages are 1. In case of wrongful termination of service, which was exactly the case, reinstatement with continuity of service in back wages is the normal rule. 2. The opposite role is subject to the rider that setting the issue of back wages. The adjudicating authority may take into consideration the length of service of the employee and workman, the financial condition of the employee, and other factors. Effective part of this code is page 30. Others are not directly deleted. That is why this honorable court has given the direction as follows. Page 30. The position number 1 states that on the termination of service, the statement with continuity of service in back wages is the normal rule. As per proposition number 2, the proposition number 1 is subject to the rider that deciding the issue of back wages. The adjudicating authority or the court may take into consideration the line of service of the employee, the nature of misconduct, if you prove against the employee, the financial condition of the employer and other similar factors, and going to the imposed judgment ordered to the such and such by a single judge. 17 of 2017, we find that the learning single judge has not made any finding with regard to the proposition called out by the apex court. Thus, we are of the view that the issue of payment of back wages would have to be again considered. However, as the decision to the facts, we are of the view that in the facts and circumstances of this case, the question of payment of back wages, if it would be best considered by the appellant. That is women. Accordingly, the appellant number 2, that is DGR, is directed to consider the payment of back wages to the respondent if any, for the period from 15/5/2010 to 19/9/2015 by giving in view the positions which have been reproduced in the foregoing paragraph, and also considered whether the respondent was employed in time elsewhere in the spirit of discharge. The appellant number 2 shall take a decision on the question of payment of back wages within a period of 3 months from the date of receival DC of this order. Subsequently, if taken full advantage of this one, the issue judgment in order that the sign such pass in WBC 17 is set aside. If taken full advantage of that since the single judge order has been set aside.
Okay, then the speaking order is passed.
My lord,
Page 32.
my lord.
What is wrong with this order? Speaking order?
My lord, it can treat that particular period to be as there as now.
Where is that?
My lord, if I will be allowed to read out the whole lot.
Is it necessary to read out the
Well,
entire thing?
Okay.
December
My lord,
15.
page 35. We have conducted what, through the DC in the SP of the consultation, which have given directly that no, he was not employed anywhere. Still, then he decided to pick up very last status now.
No, it says pensionable service, not diagonal. Come to page 36, paragraph 8.
Yes, during that period.
My lord,
That period was given
I
as
may be
notional.
allowed to take your lordship to page 35. So this is where, this is the part of the speaking order.
Hmm.
A. It is further mentioned that the Honorable Supreme Court decided such. Here, if the petitioner were to be restored in the base case, at this stage of his termination, it would amount to withholding certain increment and thus be equivalent to imposing a compounded major penalty. Therefore, considering the civil principle of law, benefits of notional pay taxation for the said intervening period, that is with effect from 55/2010 to 19/9/2015. And then follows. So it is not a backwards. And now, further the taxation of pay from 29/2015 be extended to such and such. So this is refixation. Revised the taxation in terms of 7 CPC with effect from your lordship has pointed out that 2016. This is A is clear from 1/1/2006. He also extended in error draft with A to B. Now, B, it is evident from the facts brought in the preceding paragraph that the decision of the department to declare the intervening period of absence from PD due to remaining discharge from service, that is from 55/2010 to 99/2015. And this of such and such as the yes none. That is clear. For the purpose of pay in allowance is correct as per the general principle of no work, no pay. So with this another, the court has given that no, it is to be decided as per the proposition 1 and 2 as reflected in the Supreme Court judgment. In as per the guidelines given by the Honorable Apex Court. Therefore, he is not entitled to get pay in allowances for the said period. That is it, my lord. Now, therefore, it has been decided by the respondent authority to treat the said in the renewal period from 55/2010 to 99/2015 as is pensionable service. Stop the national pay fixation benefit to be extended to such as for the intervening period to begin. Hence, is pay after reinstatement into service with effect from 29/15 be reflects notional. And errors if need be processed for making payment to him. Malone. Here, next is process for revised pay taxation in terms of 7 CPC with effect from 1/1/2016. Your lordship is clear in para 7. This is in para 7. A. Revised pay taxation in terms of some pay commission with effect from 1/1/2006. Am I clear in that? Para 7, last one. Page 35. Revised pay taxation in terms of 7 CPC with effect from 1/1/2006. We also extended in error the date to hit. Of course, as your lordship has pointed out, process para 8 plus process for revised pay taxation in terms of 7 CPC with effect from 1/1, it has come to 16, which is 206 as per the decision A of para 7. So this is a clerical error. We also extended in errors if need to update to him.
No, which one is clerical error?
Well,
Which one?
Paragraph 7.
Huh.
A last part, the direction is very clear. Last slide, page 35. Revised pay taxation in terms of 7 CPC with effect from 1/1/2006. We also extended in errors therapy date to him.
Yes.
This 2006 has turned into 16 in the para 8. Process para 8.
Okay. Which is the correct one?
One, it should be 2006. I'm bringing it that.
No, 2006 or 2016. Which one is correct?
2006, Madam.
2006?
Yes, that we have given calculation in the affidavit in presenting page. Yes, Madam.
7 CPC is with effect from 1/1/2006. 1/1/2006. There's no dispute on that.
Madam.
It's a typing mistake.
Yes. Madam, speaking order, my learned friend also have produced the 13th December 2019 India affidavit in opposition.
Yes.
If I may be allowed to refer to it.
Page?
Page 16. Relevant part is page 19.
Yes, again, same thing. 1/1/2006 and 1/1/2016.
Yes, 2006 in para 7A, but in
So is
para
this,
8
Mr. MT Longchar, is this the one which is causing the problem?
No,
Instead of 1/1/2006, they are taking as 1/1/2016.
I'm not questioning about that. On that basis, 116, page 21 will be seen. How do you work out? Of course, this is, we have shown how the error payment was made to me. Through error calculation for the period from 1 January 2006 to 30th March 2021 as per record branch number dated 9
Uh-huh.
September.
Correct. This is a calculation. Anything wrong with this calculation? They take it as 1/1/2006.
Yes, calculation is starting from January 2006.
Correct.
my lord. So this is as per the speaking order, para 7,
Yes.
last part. Of course, in para A,
Hmm.
there was a confusion, typing error, whatever it is. But in the error calculation, it started from
2006.
1st January 2006. So I do dispute against that.
Okay.
The thing is that, what I'm saying is that this is not the gain allowances for the illegal discharge period.
No, illegal discharge period, the division bench has referred the matter back to the competent authority.
My lord.
Competent authority has decided, saying that since the person concerned has not rendered his service, so on the principles of no work, no pay, he will not get his salary.
That is.
But notional fixation of pay will be given to him.
I've already given the.
Notional fixation will be done, he'll be given the arrears. But for this particular period, 15/5/2010 to 19/9/2015, he will not get the actual pay.
My lord, that is what they decided.
Ah.
But that is a different issue. The present issue is,
What are you challenging then?
my lord, the present issue is, as per the speaking order, is
Ah.
amount has been paid to me,
Okay,
which I have taken it to be the gain allowances for the particular period,
okay.
which was my mistaken statement. But when I received this one,
Yes,
this is as per the speaking order.
yes.
Nothing. But however, they are trying to make it that this was illegal payment to me. That,
Illegal payment, why?
that is what they are trying to check it, that I received this much amount
Ah.
illegally. It is not.
How they have projected, it's illegal.
Uh,
No, what are you challenging in your petition? Recovery,
page 38.
order of recovery.
Yes.
How do they say it's illegal? Let's read this page 38.
Excess amount in respect of such and such.
Hmm.
To say that I'm compulsory pension already. This inform you that such and such, this is to my command. Such and such proceeded on compulsory pension with effect from 31st March 2021 forward. Details of recovery amount is as an type of recovery amount, CPDU recovery of excess amount of rupees per plus Sunday. Only pay in allowances with effect from 1st January 2006 to 30th March 2021. How can it be excess? First thing is that.
No, what does it
Because
mean?
as per the speaking order, calculation was done. This is 70 commercial refixation, including the notional taxation for the discharge period. Malo, am I clear, Malo?
No, I fail to understand what is the reasoning here. Insofar as the orders are passed by this court, it's clear, single bench, division bench. Then the speaking order also says this is the thing.
Yes.
Now they have made the calculation.
Calculation you have given in the page 21.
They have made the calculation,
Yes.
but now by page 38, they say recovery.
Yes.
Uh, How do we understand this recovery? Let us read again. Is there any other document regarding recovery? Any notice?
This is the main document. They've already deducted certain amount, and they are still demanding that I should recover some more. 5 lakh something. Which is
Recovery
not
of
permissible.
excess
Not,
amount of.
let me take your note. This was another misrepresentation by anybody. Was your own decision, it was your payment. And they are now, they are trying to take it to be an excess amount. Even if, take it, that it wasn't excess amount. Not because of the fault of the petitioner, it cannot be recovered. So, my lord, since it is the Indian order, maybe allowed to read that.
I've not been able to understand the impugn order.
Yes. But let me explain it. This is rule. Amendment. Recovery of excess amount in respect of certain sites.
No, what is your understanding about this impugn order? Why they have recovered?
That is what
Why are they recovering?
we are trying to make it that this is excess payment to me, which is not. That is the whole thing. How can they recover a certain amount paid to me, which was entitled at a particular point of time? And now they are trying to project it as a excess amount paid to the petitioner. I think,
Please come back to page 36. Speaking order,
Malo.
para 8. This is in terms of the division bench judgment. So it says now, therefore, it has been decided that the respondent authorities to treat the said intervening period of from 15/5/2010 to 19/9/2015 as his pensionable service. The notional pay fixation benefits would be extended to so and so for the intervening period. Hence, his pay and reinstatement into service with effect from 29/2015 be refixed notionally and arrears, if any, be processed for making payment to him. Process for revised pay fixation in terms of 7 CPC with effect from, this should be 1/1/2006,
Malo.
be also extended and arrears, if any, be paid to him. So they made the calculation as per the counter affidavit
Yes,
and you have been paid.
21. Yes.
But now they come up with this order, this communication at page 38, saying that,
Projecting.
saying there's
Projecting.
excess.
Yes.
Ex-
Projecting to be excess.
Excess by how much?
The same amount.
Not same amount, it's 5,22,000.
No,
200.
they've already deducted my gratuity already.
Huh?
Gratuity, they've already deducted. Leave engagement also already deducted. 7 lakhs plus, they've already deducted.
How much have you received otherwise? 12 lakhs, 12 lakhs.
Yes, this is given clearly in your calculation sheet. 12 plus something. Page 24. This was a receipt by me after this another division page order.
Okay, 12 lakhs, 23.
Yes, something. 644.
23, 644.
Yes,
But again, out here it says 660 in page 38.
yes.
The figure also does not tally. The difference of how much? 644. Difference of 16 rupees.
I
So the picture is, calculation was made as per the speaking order, which came to 12 lakhs 23,600 something. But later on, now they say that there's some excess payment.
Yes.
And they say that from gratuity, this much has to be deducted. Leave
One
encashment
of the gratuity already deducted.
already
Leave engagement already deducted.
from how much? From what?
From the said amount of.
From 12 lakhs.
Yes,
How do you say that already deducted?
one of the, it is given here.
Where?
And you get not to read that.
Where? Show me the
It is
page.
important that such inside, type of recovery,
Ah,
such inside. Out of the above amount of rupees 12 something, only the following entitled amount can be adjusted, already adjusted. First, gratuity 4 plus, leave engagement rupees 2 lakh something. Entitled amount rupees 7 point something, you have already adjusted,
okay, see,
is
Mr. MT,
my lord.
the calculation is 12 lakhs. Now they say that you are not entitled to 12 lakhs, but you are entitled only to 7 lakhs. Correct?
No, no.
Correct.
My lord, it is the total amount, they are projecting that the excess amount drawn by me is rupees 12 lakhs 23,000.
How much is given? How much is given to you?
Yes.
How much is given to you?
That is what I received.
How much is given to you? How much did you receive? How much have you received?
My lord, as per this calculation, I must have received
12 lakhs.
plus something. Yes.
You have received 12 lakhs
So,
something.
and the specific amount.
No. You have received 12 lakhs something as per the
No.
calculation.
Yes,
How much do they want to deduct now?
the same amount.
Entire amount?
My lord,
How is it?
my lord, I may be allowed to read out the impugn order a bit more clear.
Where's the impugn order?
That is page 38.
I meant page
We are
38
saying
only.
that the excess amount, my lord, out of that, they are very clear about only pay in allowances with effect from 1 January 2006 to 30th March 2021.
Just see, my understanding is that they have made a calculation of 12 lakhs something
My lord.
as your entitlement. And they have, just a minute, and they have paid you that 12 lakhs.
Yes, my lord.
But later on, they say that no, that is excess payment.
Excess.
So you are entitled only to 7 lakhs 1,459.
No, my lord.
This,
It is
my understanding, just bear with me.
my lord.
12 lakhs they've given you, they say, no, you're entitled to only 7 lakhs. So now you must refund 5 lakhs 20,201.
My lord,
This is what they say.
no, I may be allowed to say this. Paragraph may be said. Out of that amount of rupees 12 lakhs 23,660. My lord. Only the following entitled amount can be adjusted. That is my gratuity 4 plus, my life investment 2 lakhs plus, total entitled amount which I am entitled from
So-
my discharge,
7 lakhs.
7 lakhs.
Yes.
So what they are saying is that I still have to deposit
5 lakhs.
3, yes,
5 lakhs.
yes, which comes to the total amount of 12 something.
Correct. They say that you're not entitled to 12 lakhs, you're entitled to only 7 lakhs. Please refund 5 lakhs. That's what they say.
No, my lord. The whole amount of 12 lakhs, I'm not entitled for it. This is the total excess amount drawn by me. So what they've done is that amount that can be adjusted, that is gratuity is 4 lakhs 77,000. Leave engagement 2 lakhs 23,000. My entitled out of my pension, we have already adjusted 7 lakhs something. Then Three is, in view of the above, you are requested to obtain concurrence of the individual to recover the remaining, my lord, the remaining balance amount of rupees 75. So they've already adjusted 7 lakhs. Then they are saying that to recover the remaining balance of 5 lakhs something. So it is the total amount of 12,23,660. So that excess amount which they are trying to take, they've already adjusted my investment, which comes only to 7.7 lakhs 1,459.
No, that is what they're saying. You will get only 7 lakhs. Not 12 lakhs.
No, we have already adjusted my gratuity in life engagement. So out of 12 lakhs something, only 7 lakhs something has been adjusted.
Correct.
So,
But you've got 12 lakhs.
no,
You were paid 12 lakhs.
no, this is not a question of paying. No, I've not paid in it. I was paid my entire amount. Then you are trying to predict it that I've received 12 lakhs something which is excess. Well, I may be allowed to read the whole impugn order.
No, I don't know. You're kind of, your understanding and my understanding does not tally. I don't know.
Well,
Just let us ask the CGC.
My lord.
Mr. CGC, kindly enlighten us.
Yes, Lordship. An amount of, total amount of 12,23,660
Has been paid.
Yes.
Where have you stated that?
Lordship, thereafter, gratuity and leave engagement has not been paid so far. So out of that amount, this total amount is 7 lakh 1,000. So has been deducted, adjusted. So out of that 12 lakhs, since 7 lakhs, 7 lakhs something has been adjusted. Now the balance is now 5 lakhs so and so. So it's to refund that 5 lakhs. 2,000.
He has to refund. No, how much has been paid? 12 lakhs.
Yes. In just one figure, let us say 12 lakhs.
So let us see your calculation. 12 lakhs calculation includes what? Basic pay,
Basic
DA,
pay, yes.
HRA, so and so, so and so. He has been given 12 lakhs.
Yes.
Does it include?
It does not include the gratuity and leave engagement.
Oh, that is not included.
Yes.
That's
So that is
different.
why it has been adjusted.
Adjusted in the sense that he is to get, in addition to 12 lakhs, he is to get.
Yes, in addition to that, he
He
is
has to
supposed to get 7 lakhs something. Yes.
Again.
Yes.
Okay.
But since that amount has not been paid to him, that has been adjusted before payment. Yes.
Okay, 12 lakhs is something, is a calculation which was
Okay.
already given to him.
Yes.
In addition to 12 lakhs,
He is supposed to get another 7 lakhs.
Not the addition, my lord. Excess amount of 12 something, which they are saying that I have to recover. Since I am entitled for gratuity in life engagement,
Okay.
they have adjusted that amount of rupees 7 lakh something. So they are
Yes.
still saying that I have to still deposit 5 lakh something.
Okay.
That is the whole amount of 12 something. That is the whole issue.
12 lakhs is not paid to you. 12 lakhs is not paid to you. The calculation.
No. Earlier, as per the calculation, I received 12 something.
Okay.
So when I have seen on forced pension, they calculated it to be excess payment. It is not an excess payment. In out of the 12 something, you've already adjusted my gratuity leave engagement. They're still demanding that I have to pay another 5 lakhs 22 something.
How much is he entitled to otherwise? How much is he supposed to get?
Just for a non-figure, 12 lakhs, he's entitled to 12 lakhs.
12 lakhs.
Yes. He's entitled for 12 lakhs. And
Liable.
this gratuity leave engagement has not been paid. Still in the office. So that is why that has been deleted, adjusted. And
why is it adjusted? That I don't understand. Gratuity is
so
a person
because
for
there was
person.
an excess amount of 12 lakhs, which has already been paid.
How is it? How do you call it excess?
Well, making the calculation, it was form of that.
How? You just
But
show us.
I'll-
You have to demonstrate how it has
Yes,
become
correct.
excess. Merely saying
I
excess
may be
will
allowed
not
to
do.
file a short affidavit. Making that
See,
adjustment.
merely saying that
Concludes
excess will not do because there's only one page, page 38.
Yes, only one page. We have not shown the.
How do you say it's
we have
excess?
We have not shown the calculation, Lordship.
You have shown your calculation at page 21 of your counter affidavit. 21.
Yes.
21 to page 24. This calculation comes to 12 lakhs. This is how you calculate it.
Yes.
And now how do you say that this is excess? That you have to show us. Because I think the sum and substance ultimately is that division bench, after division bench passed the judgment,
Yes.
speaking order was passed. Speaking
Yes.
order says that he will not get pay for that period.
For that particular period.
That dies none period, he will not get pay because he did not work. No work, no pay. But he will get notional fixation of pay along with whatever the CPC, 7 CPC pay increase was there.
Yes.
That calculation will be done. And if there's any amount due to be paid to him, he will get it. So you calculated 12 lakhs. Fine.
Right.
But today you're saying that this is excess. Isn't it?
No.
How it is excess? That means your calculation is wrong. Page 21 to 24. Because gratuity, whether it's dies none or not, he will get gratuity. It's money comfort. Gratuity means money comfort. A person who retires will get gratuity. And leave encashment is out of the amount of leave he has not enjoyed, you'll get leave encashment. That you cannot deprive.
Let it come out, Lordship, tomorrow, day after tomorrow, I'll verify from the office. Regarding the calculation.
Same thing. Day after tomorrow is Wednesday. You will have it on Thursday.
No.
List again on Thursday. As paid for by the parties.
For admission, item number 11.
Yes.
The petitioners are staff nurses and they were appointed in between 2005 to 2018.
Who's for the other side? Health Department. Any government council? Readings are complete otherwise.
Yes, Lordship.
If other side
Oh.
is not there,
Lordship, then let the matter come up tomorrow for admission hearing. It needs emergency disposal.
okay, as wait for list again tomorrow. Please
For
inform the other
admission
side.
hearing. Lordship.
For admission, item number 13.
Nobody?
There's a fixed item, Lordship, our matter tomorrow,
Which one?
the previous one,
I've already passed the order.
Lordship.
When the matter is got list again after a week.
For admission, item number 14.
May I please, your Lordship? Lordship, my senior is outside, so I pray that this matter may be passed over after some few items.
I was waiting outside, Lordship. Then Lee Jamo and 126 others. If this matter can be taken up, Lordship, there's an urgency. We have already made a mention before the vacation to be listed
11.
today.
Mrs. Zumami is there.
Yeah.
If the matter can be taken up. Lordship, it's a short item, short matter, Lordship.
Okay, what about this item 14?
In fact, they were apprehending that my item will be taken up first. So the senior counsel, he also informed me.
Okay, what about 13? Anybody there? No one there, no? I've already passed the order.
13 is mine.
Hmm?
13 is mine, but apparently the counsel for the respondent is not here today. Private respondent, Mr. Benang. Item number 11 can be taken up.
Some objection was supposed to be filed.
Where, Lordship?
And item 13. There's an IA.
Yes, IA is pertaining to the private respondent. They filed an IA seeking the intervention of this honorable court to direct the said respondent to constitute a village council.
Correct. So some time was granted for filing objection. It has not been filed.
He has not filed, Lordship.
So 14, you're not seeking adjournment.
No, my lord,
After some time.
I'll have to appraise my senior since
Okay.
he's ready to take up. the
Okay,
matter.
let us take up that matter then.
11, Lordship.
Item 11.
Yes.
Item 11, you cancel the order. Yes. What is this matter?
Lordship, the petitioners are staff nurses appointed in between 2005 to 2018. Now, what has happened is that the petitioners were appointed as staff nurses under district hospitals, community health centers, and primary health centers all over Nagaland. Lordship, the respondent government created 143 posts of the justice staff nurses by office memorandum dated 12/6/20. Then thereafter, advertisement dated 16/7/2020 was issued with terms and conditions for staff nurses. Then, Lordship, allow me to start from the advertisement. This is the advertisement of the,
Is this the second round?
Yes, the first round is that Untrained Nurses Association approached this honorable court in writ petition number 93, 2020. When the advertisement was made, there used to be a queue system. A queue system where the in seniority nurses were given regularization. So when the advertisement was issued, the petitioners, untrained nurses, approached this honorable court in this writ petition. However, this honorable court did not interfere and directed the respondent to conduct examination as per the advertisement. So this advertisement has already gone through the judicial review.
So advertisement was for direct recruitment
Yes, Lordship.
and the petitioners were seeking what, regularization?
Yes, Lordship. The advertisement was made. Lordship will kindly appreciate that extreme circumstances need extreme remedies, and this was during COVID period.
No, no.
The advertisement was made.
Ms. Jimosi,
So,
yes,
yes.
I understand. See, I'm just trying to understand the background.
Lordship.
The state was trying to fill up certain posts by the advertisement
Yes, Lordship.
through direct recruitment.
Through direct recruitment.
But some of the untrained, unemployed trained nurse association filed writ petition.
Yes, filed writ petition. All the petitioners filed writ petition saying that they should be regularized, appointed through queue system.
They were already working
Yes, under NHRM
on contract basis.
on contract basis. Then, Lord,
I may be, because
No,
she
Lordship.
was not a petitioner in the first petition filed by the ATNA. Lordship, I was there, Lordship.
Okay.
Lordship, what has happened is during the COVID, there was a need for healthcare workers. So the state government has created 143 posts.
Okay.
143 posts by
Staff
the first
nurse.
cabinet member. Lordship.
Staff nurse.
Staff nurse. Now, when the decision was taken, there were two cabinet decisions, Lordship. One on 6th June and the other one on 25th June. So on 6th June, there was nothing mentioned about how the recruitment to be done, Lordship. So on 25th June 2020, I have annexed in my affidavit, Lordship. I'll explain.
Then
During that exercise, Lordship, the cabinet took a decision that all the posts will be temporary in nature and the posts will be filled up through direct recruitment through special NPC recruitment drive.
Okay.
The post under question falls under NPC.
Okay.
It's a gazette post. Now, advertisement was issued. But during that time, the ADNA, the Untrained Trained Nurse Association of Nagaland, they approached this honorable court, seeking a direction from the court to give them 70% of the post and 30 to recruitment. Cabinet took a decision for 50-50.
70 for what? On
Yeah.
what basis? Regularization.
For the queue system.
queue system.
What is the queue system?
Queue system, Lordship, that is a system followed by the department. In spite of the service rule, those who got trained and passed out, they were regularized.
As
They were
per queue
absorbed
system.
As in the department.
Since
through
1988.
without going through any recruitment process, those who pass out, they were brought in service and they were regularized.
How they were brought in service? Contract.
Lordship, on contract basis.
On contract basis.
Yes, Lordship. That was a practice.
Okay.
But this was seriously viewed by the cabinet. And cabinet said, no more with the queue.
Okay.
But as a one-time measure, because of this COVID, manpower is needed. People were resigning, regular
Yes.
people.
Yes.
So the cabinet took a decision to give 50-50. That time, the ATNA, which is annexed in the writ petition, they came before the court.
Petitioners were also before this.
So they came before the court seeking a direction that no, 70 should be given to us as a one-time measure.
Okay.
And 30 should be given to direct recruitment. We contested the case. This honorable court, taking in serious view of the COVID pandemic, upheld the cabinet decision. Since this is a one-time measure, 50% will be given to queue to directly regularize them and 50 for recruitment.
Okay.
So the recruitment was done.
That was as per the cabinet decision.
Yes. Cabinet said, but temporary in nature, 50%, the remaining 50%. 50 already regularized.
Okay.
50 remaining will be temporary in nature and subject to regulation, direct recruitment by the NPSC, through NPSC. Special recruitment drive. Now advertisement was issued. They did not contest. They appeared. Advertisement was issued on regular basis, Lordship, inadvertently. Because there was cabinet decision to regular recruitment to NPSC. So department issued corrigendum rectifying the advertisement, that this is temporary in nature. When the appointment order was issued, it was temporary in nature. They did not challenge. They were given extension
Lordship.
every year. Now cabinet took a decision because of the selfless service and sacrifice given by these healthcare workers during COVID. Cabinet took a decision to relax the service rule and recruitment rules by giving them 25% marks.
25%
Marks out of the total marks. So 25% was to be given for their services, COVID duties.
Okay.
Now, thereafter it was notified. Then only these petitioners are here before us.
No, Lordship, what my learned friend is submitting before this honorable court is
Just-
adverse to the, yes, Lordship. This is my case, let me submit. He is submitting before this honorable court.
Just a minute, Mr. Zibani. Mr. Mozui,
Lordship.
that 25% for what? For service?
For the service, yes.
To be added for, against what?
In the total marks.
For the
written as well as the verbal.
petitioners.
Because there's a breakup. I'll show the
There was, that appointment was on temporary basis.
temporary basis. And the cabinet,
Although the advertisement was said regular,
yes,
but the
it was
decision
rectified.
was for temporary.
Yes,
They are twisting and turning everything, Lordship.
Corrigendum was issued.
yes,
Then ultimately when the appointment order came,
temporary.
temporary.
Yes.
Now,
No.
after appointment order comes out, what is that 25%?
Lordship, that is the result that was declared. The result that was declared.
Before the results came out?
No, no.
No, no,
After-
no, Lordship.
After they served.
Ah.
In 2022, appointment is way back in 2020,
Ah.
temporary appointment.
Ah.
They were working on temporary basis.
Okay.
Now, since cabinet took a decision, there's a clause. Cabinet took a decision saying that this will be temporary in nature, the appointment, and recruitment through special NPSC recruitment drive.
Okay.
So when they say special, the cabinet had get the thing in the mind that because of the service rendered by them, because these are gazetted posts, we cannot just directly recruit them. Lordship. They have to go through a recruitment process.
I understand. I didn't understand what that's 25%.
That 25% came later, the marks to be given
What for?
for their service, COVID duties.
Lordship, they want to advertise the post in general through NPSC and they are saying they will add 25 marks to the petitioners who are in service. Is that legal? In a competitive exam, general competitive exam, Lordship, let me submit my,
I'm trying to understand what you have stated. That's all.
yes,
That's all.
that is what they are saying.
I will
But-
hear you. I will hear you also. See, Mr. Mozui, that recruitment 50-50 already done, isn't it?
Yes.
Now,
50
what is left to be done now?
Now the 50%
Is yet,
yes, Q, Lordship,
No, Lordship.
the ATNA,
Ah.
the nurse association as such, the petitioners was also member of that association.
Yes,
They came before this court during the COVID time that no, the queue should be maintained, 70-30 at least.
no, that you've already said.
Yes.
I'm on that 25%.
Yes.
What is the
Now,
purpose of 25%?
Lordship, the 25% is not the reservation in the post. The marks to be
I
allotted.
understand.
Yes,
Now, what process remains now? Appointment is already done, isn't it?
on temporary basis.
Temporary.
Yes,
So in order for them to be regularized,
yes, they have to
They-
go through the recruitment process
they'll go through the recruitment process and you are willing to give them 25 marks,
for the COVID duty.
25% mark or 25 marks?
25% of the total marks.
25% of the total marks
Yes.
for the COVID duty.
Yes,
yes,
COVID duty.
Lordship.
So you are in for the NPSC.
Yes,
They are not for NPSC.
they are saying, no, since our appointment was done during COVID, we should be regularized.
Okay.
Through a general advertisement, already done. And this honorable court directed, under the direction of this honorable court, Lordship,
I'll come back in 5 minutes, okay?
yes, Lordship.
I just wanted to understand first,
Yes,
because
yes.
Lordship,
How the-
this is not how I'm going to decide.
Yes,
He wants to project something to make me
Yeah.
understand. I'll try to understand that. And if it's not the thing which you actually want to
that is
project,
opposite to what the judgment order has been.
then he will tell me. So ultimately
Yes.
we'll
Yes,
decide.
Lordship,
So there's a thing. Anyway, I'll come back in 5 minutes.
yes.
Lordship.
All right.
Judgment order is Prayer to kita isu kuasa. Their prayer is to question set aside the advertisement. Reduce one. And direction to appoint and regularize. Itu kan apa? Itu yang mati kena. Ni sade. Just a scrutiny. Okay. So we did this. So. 11. Apply that.
May it please, my lord, I beg my lord's indulgence. Lordship, it appears
Yes.
item 11 is likely to continue beyond the lunch break. As such, I may be kindly allowed to make a mention for item 23, Lordship. Here, I want to file an additional affidavit. Since it is in the order stage, I did not mention it during the mentioning hours. Lordship.
Okay.
I've been sitting since this morning.
Your-
And Lordship,
Your
the
for
petitioners
which,
have also been directed to take fresh steps upon the respondent number 7 by order dated 12/12/2023.
you are for which respondent?
I am for respondents 1, 2, and 3.
What is your prayer?
My prayer is, Lordship, to file, I may be granted a week's time to file an additional affidavit. With the additional affidavit filed by the state respondents, because in the additional affidavit filed by the state respondents, Lordship, as per this honorable court's direction, one additional affidavit was filed by the state respondents, Lordship. Now, in that affidavit, the entire facts has not been clearly protected. So, which is why we want to make some, we want to. protect
You are the private respondent.
No, my lord. I am for NHITCL, the Union of India, the NHITCL respondents 1, 2, and 3, Lordship. The entire thing has been prepared, but the authorized signature, Lordship, he is out of station. He is in Delhi. He will be returning within the course of the week. So
What is your stand? Is it in conflict with the stand of the other respondents?
Not necessarily in conflict, Lordship, but we want to protect the entire, because only, not the entire facts, but only a very simplified story has been protected before this honorable court by the state.
Yes, you are there for the,
For the petitioner.
any objection?
Yes, Your Lordship. As per interim order 12/12/23, fresh step has been taken upon the respondent number 7, and the service report is awaited.
Okay, as paid for by Mr. Sentianger, learned counsel for respondent numbers 1, 2, and 3. A week's time is granted for filing additional affidavit. Service report be awaited from respondent number 7. In the meantime. Yes.
Keep the blacks, my lord.
May it please, my lord.
Yes.
Lordship, the petitioners are the first batch in the history of staff nurses, where they were the first appointees through advertisement. Since 1988, service rule is there, but queue system was practiced, and we are the first batch who were appointed through general advertisement. Lordship,
Where is the advertisement?
yes. So the advertisement is at page 31D. We are on this, Lordship. And this advertisement has gone through the scrutiny of this Honorable Court in the previous writ petition, where neither the respondent brought up this, where against this advertisement, they are now pleading before this Honorable Court. It was by mistake, this advertisement was made, but in the first writ petition, they did not object to this advertisement, and now twisting and turning
Okay.
according to their wishes and coming before the Honorable Court
You-
saying that.
You read the advertisement
Yes,
first?
Lordship.
Uh,
Government of Nagaland Directorate of Health and Family Welfare, Nagaland.
Page 32 is the type copy.
31. Page 31, Lordship. Annexure D. Page 31, Annexure D.
No, you have a typed copy of this order. Page 32.
No, yes, yes, Lordship.
Yes, that's more legible.
Yes, yes.
31 is all black. na?
So this is a regular advertisement,
Please read.
16 July 2022, advertisement, number so and so. In pursuant to notification number so and so dated 26 June 2020, and Health and Family Welfare, a COVID appointment so and so dated 2nd July 2020. Applications are invited for recruitment against newly created posts on regular basis. We are on this, Lordship. Regular basis under the Department of Health and Family Welfare through the Department Recruitment Board in the manner prescribed below. Name of the post, staff nurse, number of posts, 110 posts in various health units. Pay matrix and level 8. 4. Terms and conditions and prescribed format of application can be downloaded from the department website so and so. 5. Last date of submission of application shall be 25th July 2020. Duly filled application in PDF format along with requisite supporting documents should be submitted through email to so and so.
Just
And B.
Just a
No,
minute before you make it. They were saying 143 posts, but
Yeah.
here it's only 110 posts
110 posts. Later on, it was added.
later on.
Yes, Lordship.
Okay.
I'll just satisfy my lord. Now, the terms and condition of the staff nurses, Lordship, whether this is a contract advertisement or whether this is a regular advertisement, they said regular advertisement, and my lord will just peruse. Terms and condition for staff nurses, eligibility criteria. Those who have resigned, Lordship, we were made to resign. We have served more than 13 years, 16 years above in NHRM. We were made to resign.
How? Is it provided here that you have to resign?
Yes, here it is, those who have resigned from contract service without any valid reasons during the COVID-19 pandemic crisis shall not be eligible to apply for this recruitment drive. Lordship, many, even the regular appointees at that particular time,
Where is it given like that?
page 33, I'm reading page 33, Lordship. Terms and condition, page 33. My lord has got it.
Yes.
Eligibility criteria. Those who have resigned from contractual service without any valid reasons during the COVID-19 pandemic crisis shall not be eligible to apply for this recruitment drive. H on 1/120, so and so. This may not, Lordship, I may not read out
Not required.
this, or shall I read out, Lordship?
No, not required.
Lordship. B, desired qualification, GNM or BSc nursing degree from an institute or university recognized by INC. C, registration with state council. I may not read out, Lordship.
Not required. See,
Yes,
this is the advertisement in 2020.
Lordship.
You responded to this advertisement.
Yes, my lord. We are recruited through this advertisement, and since it is on regular basis, we served in NHRM for 15 years,
Okay.
till
go-
17
Please
years.
go step by step.
Yes.
See, this is the advertisement, then the corrigendum comes at page 35.
Corrigendum, this was
Any changes?
corrigendum, this is for laboratory technicians and doctors. This is not for nurses.
Okay, this is not for us.
Yes. Now they are trying to, behind this, they are trying to say that corrigendum was issued, but it was not, Lordship. So this is the corrigendum that was never published in the paper, and now they are standing on this, saying that our regular appointment has
Ms.
been.
Zimomi, you complete the factual part, then you come with the submission.
Lordship.
You're making the submissions first and taking to the facts also.
Lordship,
So let us go step by step.
Lordship.
Advertisement is at page 32. There is no corrigendum for nurses.
There is no corrigendum.
But
for
you said that
nurses.
there are some other posts which was later on added. Because the advertisement speaks about only 110 posts of staff nurse.
I will come later on, Lordship.
So it is by a different recruitment or same recruitment,
Same recruitment.
remaining balance.
Yes, same recruitment.
How was it notified? Was there a separate notification for the remaining balance post?
Balance post is in the Lordship, in the notifications.
Where is that? What is this addendum?
This addendum is showing that page is 37, E2. This addendum is issuing corrigendum stating that further implementation of reservation policy for indigenous inhabitants of the state of Nagaland and backward tribes, etc., shall be met in accordance with the terms of the existing reservation policy of the government of Nagaland issued from time to time. This also will show that, Lordship, this is in a contract appointment, never reservation policy are applied in the state. So the terms and condition of the advertisement is regular recruitment, Lordship. That is what I want to appraise before this honorable board. Lordship, the first.
So you participated in this advertisement?
Lordship,
Recruitment.
Lordship.
Where is your appointment? You were appointed?
Our appointment is more than thousands applied, Lordship. Then after this, Lordship will kindly come to page 77. Next year G,
Yes, what is this?
staff nurse post addition, addendum.
19 posts added.
Yes, Lordship, in continuation to the advertisement dated 16/7/2020 with regard to the recruitment against newly created posts of staff nurse 110 posts under the Department of Health and Welfare through Department Recruitment Board, it is hereby notified that an additional post of 19 shall be added to the existing 110 posts. The total number of posts for the staff nurse should be read as 129 posts. So this is the post, Lordship. All other terms and conditions, my lord will kindly appreciate, all other terms and conditions as notified earlier shall remain as notified earlier.
Okay.
There was no changes at all. My
Now,
lord, this portion,
It comes 129. What about the remaining? Sanction was 143.
sanction was, yes, Lordship, let me, at least this is my case, let me explain, Lordship.
The queue comes here, Lordship.
The queue comes here. The
There
queue,
was 143 was created. There were already existing vacancy. It was clubbed up, and then for their 50-50, 50 was given to queue. So 129 came out, the 50 recruitment.
so what has
So
happened
the
is,
143.
Lordship, the queue came in. This was challenged before this honorable court, and this honorable court declared that the queue system is unconstitutional.
No, what is that queue system? How did it come? Please explain. Nothing is mentioned in the advertisement.
Yes, Lordship. That's why this honorable court directed to go by this advertisement.
No, this honorable court passed the order only when somebody filed writ petition. You please go in chronologically. What happened? How did you come to the court? Who came to the court?
Untrained Nurses Association.
So
that is-
far, I have understood, advertisement was issued for regular basic appointment for staff nurses, 110. Subsequently, addendum was made wherein another 19 posts was added and the remaining terms and conditions remain the same.
Lordship.
That much I've understood. Then what is the next step?
Then what has happened is, Lordship, in the first writ petition, the petitioner approached this honorable court to quash and set aside the advertisement dated 16/7.
Before the recruitment started?
Yes.
Writ petition was filed?
Yes, Lordship, before the recruitment.
Okay.
So they came before this honorable court in writ petition number 93/2020.
Okay.
To quash and set aside the advertisement, the present advertisement.
What,
Lordship.
what was the reason? On what grounds?
And seeking direction to appoint and regularize as per existing queue system.
Okay.
Existing queue system.
But how do we
The
appreciate-
judgment order is at annexure F, page 8.
How do we appreciate the queue system?
That's why, Lordship, let's read the judgment order.
No, is there any document as such which says that this is the queue system?
Queue system was declared by this judgment order, queue system was declared unconstitutional and the respondents were directed to, the petitioners were directed to appear for the advertisement, Lordship.
So what I meant was, see,
Yes.
somebody came to the court challenging that queue system. Where is that queue system? Can it be seen anywhere here? Any
No.
document?
Not challenging, to implement the queue system.
Or to implement the
To
queue system?
implement, to implement the queue system, challenge the advertisement and to implement the queue system, Lordship. So this honorable.
There's no
court-
document showing that this queue system should be followed, Lordship.
Queue system is,
Just a
As per the
practice.
it is a practice.
practice,
Wherein 50% of the post which is to be filled up
yes,
is filled up through those
through queue system,
is filled up through those persons who are already in service
Lordship.
on
Lordship,
temporary basis.
Not 50, 100%. Department was following that 100%. All the vacancy that arises, those in seniority will be regularized. So that was the system.
So there will be no fresh appointment.
No,
Yes, there was no fresh appointment.
There
So
was-
cabinet,
If you-
they make it 50.
If you want to be appointed to a government post,
No need for recruitment.
first you have to be appointed temporarily on contract
Yes,
basis
that
or
was the system.
on stopgap arrangement.
Yes, stopgap arrangement.
And later on, when there is vacancy,
They get,
then they'll put you in.
So,
that was the system.
so for implementation of this queue system, we approached this honorable court. However, this honorable court declared that queue system is unconstitutional and as per the direction of this honorable court, this recruitment process was done. And the petitioners, 129, now four others were left out and the petitioners were the first batch who were recruited through open advertisement.
The present petitioners,
Yes, Lordship.
they were also a part of the petition in
Yes,
that
yes,
case,
Lordship,
part of the association,
Lordship,
Unemployed Trained Nurse Association,
Lordship,
represented by President, General Secretary.
Lordship.
Okay. Now, where is the operative portion?
Operative
this
portion,
judgment?
Lordship, in the interest of justice, Lordship, it's a little bit long, but it starts from paragraph 15. This honorable court, page 70. The queue system that was declared unconstitutional before this by this honorable court. Paragraph 15.
Yes, read.
The first issue that needs to be settled in this case is whether the queue system of appointment, which is claimed to have been followed in the appointment of nurses for the last many years, is valid under the constitutional scheme and under the settled principle of law, Article 14 and 16 of the Constitution of India, which is as follows.
Need not read. You need not read.
We will then, Lordship,
Then you need not read that.
the operative portion 72, last para, Lordship, allow me to read out from you.
72.
Yes, after declaration of this honorable court, instead of regular which existence is not shown on paper except through reference to some documents as submitted by the Learned Council. List of trained nurses are maintained in serial depending on the years of completion of their nursing training graduation. And as and when vacancy arises, those who are senior in the list are appointed. The appointment to future vacancies continued likewise. One must remember that posts in public service are created to serve public interest in the first place, and the opportunity to be appointed to such posts is a consequential benefit. In other words, the first and foremost important reason on purpose for creating posts in public services is to serve the public interest and not to provide employment per se. Therefore, when the state government creates posts, the first and foremost importance one must give is on the quality, on merit of the persons to be employed. And such can happen only if the opportunity is open to every eligible candidate to apply and appear in such recruitment test as required under Article 14 and 16 of the Constitution of India. In the case of queue system, such opportunity is not only denied to all eligible candidates, but the chance of finding the best or selecting the best for the job is already curtailed. Therefore, the queue system is not only against the scheme of equality provided in the two articles, but against the public interest. Such practice as such, even if it existed for a long time, must go. It is true that society evolves and the law also evolves as per the need of the society. Such practice might have been suitable in the time past, when there were not many people who went for nursing training. But the days have changed, and so is the need of the society. The society must move on, and the laws, which includes the customary practices and all other practices which were relevant at one point of time, have also to change. The practice of yesterday, however good and relevant at that time, may not be appropriate anymore for today. The state of Nagaland needs the best medical personnel available and not every trained nurse. Therefore, the best, even amongst the best, should be selected to serve the interests of the people of the state. And while doing so, every eligible and interested person should be given the opportunity to appear in the selection process, and the same should be based on merit. The interests of the people of the state should not be superseded by the interests of you. I am unable to accept the submission of the Learned Council of the petitioners that the equality principle has not been violated by the queue system of appointment, since intelligible and reasonable differentia has been taken care of by the system, because it is not the intelligible and reasonable differentia or classification contemplated by the Constitution. In the name of such classification, the juniors among the trained nurses cannot be denied equal opportunity.
Now, you come to page 75, last para.
75 last para, Lordship.
As such, I find nothing.
As such, I find nothing illegal in the impugn notification and the impugn advertisement. In particular, in any case, as stated above, the validity of the second part of the case of the petitioners depends on the result of the findings made in the first part, because when it has been decided in the first part of the petitioner's case that appointment through queue system is not within the constitutional scheme, appointment to the post of 143 staff nurse created by the decision of the first cabinet sitting on 11/6/2020 could not have been allowed through queue system alone. Furthermore, from the reading of the minutes of the two cabinet meetings, the notification issued thereafter, it appears that it is an emergency and one-time measure taken to deal with the health issues of the people of the state arising out of COVID-19 spread. Therefore, this court has no inclination to interfere with it. However, regarding the maximum age of eligibility, which is extended to 45 years in the case of serving contractual employees, I am of the view that the same relaxation should be extended to all the trained nurses of Nagaland, considering the fact that many of them did not have the privilege of being appointed on contractual basis, and as such opportunity to compete for appointment comes very rarely. Therefore, the respondent are hereby directed to extend the same benefit to all the trained nurses in Nagaland to enable the persons who have not applied for the selection process due to overage. And the respondent shall extend the last date of submission of application till 4 p.m. on 31/8/2020 and thereafter conduct the examination at the earliest in view of the immediate needs of the medical personnel in the present situation. The extension of the date of submission should be published in the newspaper and other medias so that the intended candidates all around the state may be able to know the same. The writ petition is disposed of in terms of the conclusion drawn, observation made and the direction given. So, my lord, this advertisement went through the scrutiny of this honorable court in the first writ petition, and this honorable court has directed that as it has to go as per the advertisement, and as per the advertisement means on regular basis for the petitioners before this honorable court. Now, this is just a crux. This is the just crux of the case. Now, what has happened is, my lord will kindly this 19 posts were added after the page 77 were added, and 129 posts, 129 posts as per the advertisement exam was conducted, and there were more than thousands, lordship. Lordship will kindly come to annexure I, page 79. These are the shortlisted names of candidates for Viva.
Yes.
So, my lord.
They include the petitioners?
Yes, yes, lordship. So,
124 petitioners in the present case?
In the present case, lordship.
All of them are here?
Yes, lordship.
In this shortlisted?
Out of 129, only 124.
No, for, yes,
The
for
remaining, they have resigned.
Sorry?
They have resigned.
124, 25, 26,
129
27,
posts
28,
was
29.
included,
Advertised.
lordship.
Some resign, some went for new other appointment, and so 124 are here before the honorable court amongst the petitioners.
No, correct. There are only 124 petitioners.
Yes, before the honorable
What I
court.
asked was whether these 124 petitioners were also shortlisted for
Of
interview.
course, lordship.
They are part of this list.
Part of this list, lordship.
Then ultimately you were selected.
All of us, 129, the petitioners were selected out of thousands. Lordship will kindly come to, the first petitioner is at serial number 40.
Petitioners is 124. How do you say 129?
No, serial number, shortlisted candidates. This is for Viva, Lordship, Viva. The shortlisted candidates.
Shortlisted candidates are total numbers is 194.
Yes, shortlisted candidate is 193.
194.
There was no written examination, just the shortlisting was done as per the marks secured by the candidate.
No problem. 194. How do you say 193?
Here in my
Page 82 is 194 total.
86, in my one.
82, page 82.
55, 130.
79.
71.
79 is the beginning.
Yes, Lordship, I beg your pardon.
194.
I haven't, yes, Lordship.
So out of this
There
amongst these 194 shortlisted candidates, the present petitioners who are numbering 124 are
Yes,
also there.
Lordship.
Are also
Lordship,
there. Okay.
Lordship. There were two batches. Another one is Group B, is shortlisted name is at page 83. There were two, Group A and Group B. So the petitioner figure in both. Group A, shortlisted names of candidate for Viva, and Group B is at page 83, next year I1.
What is the difference with Group A and B?
That is how, Lordship, Two,
So total how much?
total is 193 plus
208. Again 193, it's 194. Why do you keep on saying 193? It's 194.
shortlisted candidate,
Uh-huh.
Lordship. My. Plus 192.
194 plus 208.
Yes, Lordship.
Group A and Group B.
Group B is,
Why is it grouped in two groups, Group A and B? Any difference?
no difference, Lordship, it's just, they were listed, all this were listed for Viva.
The group was made so that since there was no physical interview possible during COVID time, it was done through Zoom. So they have divided into two groups. So altogether,
total is how much? 402?
Yes. 197 plus
208.
194 plus
208.
193, yes.
193.
194 plus 193.
193, that's why I'm confused.
Where is that 193?
Group, page
190
86.
Page 86.
193, Lordship, page 86.
Oh, 193, okay.
Yes, one is 194, one is 193. 387.
There
We
were
are short-
387 candidates.
Shortlisted
For
for
129
Viva.
129 posts. So the group is to segregate for the date of interview through Zoom.
Okay, I understand.
Yes.
Then next.
Then after this, Lordship will kindly come to page 102. This is the appointment order of the petitioner issued. Common,
Okay.
a common order was issued. Type out one by one, Lordship, for clarity. So these are the petitioners.
All the petitioners are here.
All the petitioners are here except serial number 28.
Serial number 28 of what? The list?
Yes, page 104. Expired.
Oh.
Out of 129, I just want to impress my lord that at serial number 28, expired.
Metsoy.
Yes, Lordship, Metsoy expired. Then serial number 35 resigned. And Lily Ism resigned. Then serial number 44. Vivo no Zatsu. She refused to accept the appointment order. Then then 99 resigned. Serial number 99. After the selection, these are the candidates who resigned, Lordship.
Yes.
So this is how 24 petitioners are before the Honorable Court. So my lord will kindly see as to how the appointment order was issued. In person, 102, first page. Next year L. In person to letter number so and so dated 2nd February 2021. The following GNM BSc NR hereby temporarily engaged from the temporarily engaged to the post of staff nurse and posted to the undermentioned places against new post creation, retirement vacancies at level 8 of the new pay matrix of ROP 2017, pre-revised payment of rupees 5,200 to 20,000 1,200 with grade P of rupees 2,800. The engagement shall be as per the following terms and conditions. The engagement shall be for a period of 12 months only, or till regular appointment is made through NPSC, whichever is earlier. The appointees shall have no right to claim for regularization of the engagement on contingency basis or any ground whatsoever. Here, it's not that very clear. So, three. No sundry service benefit such as earned leave, save for 12 days of casual leave, shall be admissible during the course of the 12 months contingency engagement. The agreement carries with its liability to serve in any part of Nagaland. The engagement shall be liable to be terminated at any time without any notice and without assigning any reason thereof. 6. If any candidate is found keeping proxy, the engagement will be terminated without any further communication. 7. No transfer will be entertained during the engagement period. So this is how Lordship, from regular advertisement, they turn round and turn the appointment of the petitioner as contingency. Now, Lordship,
What is the date?
this is appointment of the,
Is it 15 April?
this is the 15th April 2021.
Okay.
15th April 2021. Now this appointment order, at that time, none of the petitioner could get the appointment order because all of them were in their respective posting place. And during COVID time, there was, as my lord is conversant, lockdown. So this was never within the knowledge of the petitioner in most of the cases.
Lordship, they were not appointed and they were in the place of posting. Lordship, how is it possible? Without appointment order, how could they be there in the place of posting?
No, wait. That is another thing.
They're saying they were in the place of posting. Appointment order was issued. After only getting appointment order to go,
Lordship,
it was given to them.
they can easily submit like that, but prior to that, all the petitioners were in all the district under NHRM, the petitioners. So during COVID time,
Petitions were already working,
yes, under NHRM,
NHRM.
yes,
On what basis? Contract basis?
on contract basis. And they were serving since 2015, appointed
No.
since 2005.
What is the term and condition for appointment under the NRHM?
Contract service,
And is
termination as and when the
is
central
it-
government,
is it for a specific period?
as and when the
Every year is
scheme,
extended. Every year is extended.
scheme is allotted by the central government on extension basis.
They are appointed for 1 year at a time.
Yes, Lordship.
After 1
And
year,
ex-
again extended.
extended,
Okay.
Lordship.
So all the petitioners were working under
Lordship.
NHRM.
Yes,
And services were extended from time to time.
Lordship.
But they also responded to this advertisement.
Yes, very much.
They participated and
Yes,
and this is the appointment order.
yes, they resigned. They were made to resign, Lordship, in the NHRM.
They were made to resign.
Yes. They resigned and joined this second advertisement post,
Second advertisement.
this advertisement, to respond to this advertisement.
No,
They resigned in the previous post.
How
Some
many-
were
How many advertisements are there?
only one.
16 July
Yes,
2020.
only that.
Okay. So in the terms and conditions, does it say anywhere that they have to resign?
Lordship,
Why did they resign?
to be clear of it, Lordship, let's better go to the terms and terms of the advertisement.
33. It does not say that you have to resign.
We
Why-
were asked to resign and to join the new post.
The terms and conditions is there.
You were asked to resign from the NRHM
NHRM, all of us resigned from NHRM and
and you were asked to join as per this order dated 15 April.
yes, Lordship.
Of course,
the
because
advert-
you cannot work at two places at a time,
yes,
isn't it?
yes, Lordship.
If you were already working under NRHRM, that was on contract basis. Once you are appointed as per this order dated 15 April, then you'll have to go and join that post. You'll have to choose either one of them, isn't it?
Lordship.
So if you do not
Lordship,
want to join, then you have to resign. You have to decline the appointment. You cannot join in two
Lordship, what
places.
happened here is the petitioners were serving on contract basis.
Yes.
So when this regular advertisement was issued by the respondent government, at least they've been serving since some of the petitioners have been serving since 2005
Correct.
under NHRM. So
So you are being member of that association. You want that queue system to prevail.
yes,
But the writ petition failed.
failed.
So advertisement was put in motion. You applied for the post. You were appointed as such, but to your surprise, you found that it was
Yes,
only a
yes.
temporary appointment.
That is the gist of our case, Lordship. The
But
advertisement was
advertisement said it was a regular appointment.
appointment. That's why we all resigned in the previous NHRM and we appear for this advertisement.
Okay,
Lordship,
I've understood.
yes, only
Then-
that our grievances is that. And what has happened is, after this honorable court passed that order declaring that queue system is unconstitutional, after 3 months, more than 3 months, they again gave appointment on regular basis to add another 129
Regular basis.
regular basis.
Where?
In violation, Lordship, I have annexed it.
Any advertisement for that?
Yes, even after declaration of queue system and instead of giving regular appointment to the petitioners who were appointed through general advertisement, they instead regularized the service of the other 129 through queue system. This is the gist of our case, Lordship.
Show me that.
Now,
Where is it?
annexure J, page 87.
So after this order of appointment was issued, you resigned from your NRHM post and you joined.
Yes, Lordship.
And in the meantime, another advertisement came.
Not advertisement.
Then,
This is the only advertisement.
no, you said another set of people were regularized.
Another said, page annexure J 87, were again regularized by the respondent government after the
Where, which one?
passment,
Which one? Page,
page 87.
who are these?
They were 129 of them. They were another part of nurses who were regularized, appointed on temporary basis means regular appointment, given regular appointment through queue system. Lordship will kindly see 15 December 2020. That is after the passing of the judgment order by this honorable court, which was passed on, my lord will kindly see, passed on 28/8/2020. The judgment was passed on 28/10/2020, declaring queue system as unconstitutional and illegal. And direction was given for regular recruitment.
No, that was in respect of this particular advertisement in particular, isn't it?
Yes, but instead, again, the respondent again regularized the service of 129 at annexure J, page 87. Nurses. Instead of giving regular appointment to the petitioner as per the advertisement, they instead regularized the service of this 129.
This is a temporary appointment, Lordship, because there was need for manpower.
No, Lordship.
I don't know what is happening.
Lordship, can you see the paragraph 2 of the notification? The appointment is temporary, purely temporary basis.
They were appointed prior to the petitioner's lordship. I have, in my affidavit in opposition, I have annexed seniority list.
In your affidavit of position,
Yes,
you are the petitioner. How do you say you file affidavit of position?
in my affidavit in reply. I beg your pardon, lordship.
You'll oppose yourself.
Yes. yes.
Otherwise.
Yes, yes. In my affidavit in reply to the,
No, just a minute. I'm at page 87, all right?
yes, lordship.
In persons to letter number so and so dated 27 November 2020. What is this?
Lordship, this is annexure J. In my writ petition, it will be clear.
I'm looking at annexure J only. So.
Serial number 1, Lily, the one who refused, who resigned. Serial number 25. It's them only, lordship.
I'm just a little bit.
It's 129 of them.
1 minute, lordship.
My learned friend can cross-check the name.
No, lordship, they were appointed in queue system. These were not the petitioners. I cannot be this much wrong. Kindly let me submit my submission.
See, I'll tell you. So far as this much I'm clear,
Lordship.
advertisement was issued, and then the petitioners were not happy with the advertisement, saying that they should follow 100% queue system, approached this court by filing WPC this 93. But court said that queue system is unconstitutional, so
Yes.
there is nothing wrong with the advertisement. Please go ahead with the advertisement. So petitioners participated in the advertisement. They were shortlisted for the Viva Voice.
Lordship.
Ultimately, an order of appointment was issued on
Lordship.
15th of April 2021. Out of which, not all of them, but except for 4 of them, I think, they resigned or refused.
Yes.
1 expired.
Yes.
So the remaining, they were
124.
appointed. The petitioners were appointed, and the petitioners who were working under the NRHM on contract basis, they resigned from NRHM and they joined their respective post.
Lordship.
Now, why have you come before this court? You were selected.
We were selected, we were appointed. Now, Lordship, they have changed the, Lordship, will kindly come to.
You're unhappy with the terms and conditions of your appointment.
Lordship.
You say that it should be a regular appointment.
Yes.
Not a
as per the
temporary
advertisement.
appointment.
As per the advertisement. Lordship, let me. Lordship.
And then you point out that while we were appointed on temporary basis, despite the advertisement being regular basis, some other people were appointed, they were regularized by following queue system.
Lordship.
That is page 87.
Yes. Lordship, will kindly come to page 36. E,
That-
we are on this.
36.
This- Yes, in violation of principle of natural justice, they issued this corrigendum without the knowledge of the petitioners. And this was never published. And from the regular appointment, they changed our appointment into temporary appointment.
36.
36, page
Next,
36. We are on this.
E1.
E1. This is 17 July 2020. This was never published in the public domain. Any corrigendum appears in the newspapers. So for others, for corrigendum, they publish in the newspaper, and this was, Lordship, we are sure this was backdated and this was never published in the newspaper. In the official newspaper, they publish this and change the condition of our service. Corrigendum. In connection with advertisement dated 17 July 2020.
17 July.
17 July 2020. This was never in public domain. We never knew about this. Even in the first read petition, this was never.
But the advertisement is 16 July.
The next day they issued this corrigendum. Well,
No, no.
purportedly,
The advertisement was issued on 16 July.
16 July. The next day,
Corrigendum is 17, what?
17 July.
17 July.
Yes, Lordship, 2020.
That's okay. But read the first line. It says, in connection with the advertisement dated 17 July. There is no 17 July advertisement in the first place.
It is their mistake, Lordship. It is, the advertisement is
So I think we'll take a
16 July.
break. Yes. We'll take a break and come back. By the way, these persons who were appointed, which you say were appointed
Oh.
on queue system,
Lordship.
are they a party?
No,
You're challenging their appointment, regularization.
no,
You're not challenging.
no.
But then it's
We-
okay.
Lordship, but the fact remains, these people have been appointed for because of the acceptance of service, Lordship.
What about us?
They were also appointed on temporary basis.
No, no,
Both the
whatever.
group, both the group.
Whatever may be the reason, if you are aggrieved with the regularization of
If
these,
they say so, let them challenge.
then you'll have to challenge their
That,
appointment.
Lordship, 129 post is different. That is a different post.
Lordship, my
And
learned
our-
friend should be concerned with the post creation and the vacancies. Lordship,
That's why
I'll show
our
the
post-
breakup. I'll show the breakup.
Lordship, after the breakup,
okay.
I will satisfy this agreement.
All right, we'll come back at 2.
Lordship.
Lordship, there is a supplementary list which we are not aware of, and neither it was uploaded in the website, Your Lordship.
Okay.
52, 53, 54. So I pray that this matter may be released next Monday, Your Lordship. Even the opposite council was not aware of the supplementary list.
Okay. You're Mr.
I, Jamir, Your Lordship.
Mr. Oh, it's not there. Okay, we'll pass orders once I come back in the afternoon. Okay.
Obliged, Lordship.
Oh, 115, no.
Same year, I come here, I give it.
Please, Lordship.
Yes.
Lordship, I beg to mention supplementary item number 52 and also 53 and 54.
Oh, you had mentioned, no?
Lordship.
When do you want it?
12th, Lordship. Next
For
month.
the, for the petitioner.
Lordship.
As paid for by the learned counsel for the petitioner, is the matter again on 12th of February 2024.
Similar prayer for 53 and 54.
Yes, 52, 54, same order.
Obliged.
I beg to mention item number 26.
Yes.
Lordship, I have instruction to appear on behalf of Mr. Y.P. Gupta, the learned CTC for the Ministry of Tourism.
26.
Yes, ma'am. Respondent number 5. So the respondent number 5 is appearing for the first time today, madam. So sometime may be granted to file my appeal.
What is your good name?
Mane Konyak on behalf of Mr. Y.P. Gupta, ma'am.
Mr. M. Konyak.
Yes, ma'am.
Appearing on behalf of Mr. Y.P.
Gupta.
Y.P. Gupta.
Learned CGC for
Learned CGC. Submits that Mr. Gupta will be appearing on behalf of respondent number 5. And he needs how much time? 2 weeks time. To file power.
Yes.
To file his power. Next para, in view of above. Notice upon respondent number 5 is complete. This is the matter again after 2 weeks to await the service report from respondent number 6.
May it please, my lord. Lordship, I will, for clarity, the other 129 appointed were other vacancy posts. Now, my lord, the respondent created 221 new post creation. I will show, my lord. One is page 26, annexure A1. Five. Plus five, creation of 143 posts of staff nurse to be deployed in all district hospital. The cabinet has also approved for appointment on the existing system of the nurses while ensuring judicious deployment in a just and fair manner in the hospital health centers. The existing instructions on reservation of posts for the backward tribes should be followed. This is the first one. The second 78 post creation is at annexure B, page 29. Serial number 6. Second post creation. Staff nurse for PHCs, 78 post. This is clear, Lordship. So these are the new post creation, and where the other 129 were appointed, where 129, the post held by the petitioners, they want to send it to the NPSC for advertisement. Out of this, 221 posts.
143 plus 78.
78 is 221, Lordship. So this is a new post creation. So out of this, where the petitioners were appointed, 129 posts they want to advertise through NPSC. The rest in the same post creation order. 92 balance plus retirement vacancy that arose in the department. They have appointed the other 129 through queue system. On 15 to 12, 2020, after more than 3 months, after this honorable court declared is unconstitutional. This is how they became senior to us petitioners who were appointed through open advertisement. Our appointment was issued on 15/4/2021. If we look into it, Lordship, it's unfortunately, it's very discriminatory. So ours is 15/4/2021 appointment order issued. So we became those who were recruited as per law were met as juniors, and we were being asked to appear for the NPSC, whereas this other 121, how those 121 were recruited in December through queue system. So there is a blatant discrimination among similarly situated nurses, Lordship. My Lord will take into consideration the aspect even after the direction of this honorable court. So those 121 were pick and choose and appointed in December, whereas we were met to appear for the exam and we were selected through merit, where thousands applied for it. Lordship will see the numbers, it's more than 1,000. So that is the clarification, Lordship. That The learned government council is saying that we have not challenged, but no. Ours is specific post creation that they want to send through NPSC. Those others balance, they have appointed other people, similarly situated person, applying different yardstick, queue system, they were appointed as temporary, but those are regular appointment as being practiced by the department for decades. Now, my lord, that is clear. So we did not challenge 129 because their post is, vacancy post is different. And even in their appointment order, it is clearly written, Lordship will, annexure J87, their appointment letter, it is stated that at page 87, annexure J, those appointed as per queue system. In person to letter number so and so, dated 27 November 2020. The following GNM, BSN, NR hereby temporarily appointed to the post of staff nurse and posted to the undermentioned places against new post creation, that is, Lordship, 92 balance, obliques, retirement, obliques, expired vacancy at level 8 of the new pay matrix ROP 2017 pre-revised pay band of rupees so and so, plus all other allowances as are admissible under rules from time to time in Nagaland with effect from the date of issue of this order. The appointment comes under the purview of the new defined contribution pension scheme. So that is a regular appointment, Lordship.
This is queue system.
Yes, queue system.
Queue system.
Yes, Lordship. So instead of the petitioners giving regular appointment as per the advertisement, the respondent instead have appointed them on queue system on regular basis. This is the system that has been in practice for decades, Lordship. So this aspect, Lordship, is very tricky. And now they are making us as contingency paid appointee. Now, after this clarification, Lordship will kindly come to the next corrigendum. Page 36, annexure E1. This we have challenged. We have challenged for notifications and this corrigendums in our repetition, in our prayer. Now we have challenged this C, clause C. What has happened is, in this connection, my lord, the previous confusion, 17 July, they are saying 17 July. In connection with the advertisement dated 17 July 2020. Now it has been clarified that, Lordship, the notification by the department came out on 16 July 2020.
Yes.
The previous one that I have read out. The notification by the department advertisement was issued on 16 July. Then the next day in the local dailies, the advertisement at page 31, annexure D was published on 17 July. Yes, 17 July. So that is why they have mentioned in continuation with this, that was published, officially published in the newspaper, page 31, annexure D. That's why it has been mentioned as 17 July, Lordship. Whereas the department issued on 16 July.
This was in which paper?
Lordship, this will be obviously in Nagaland Post, because that has a wide reading. So mostly the advertisement were issued through Nagaland Post. Here, they have not given issued by DI, newspaper name is not here, Lordship. But presumably, Lordship, in Nagaland Post.
This is your annexure only.
Yes, Lordship.
You should have said.
If
You should have said in your statement against paragraph 9 or paragraph this is what,
This
5,
is 5.
that the notification or advertisement dated 16 July was published in the daily Nagaland Post Daily on
Lordship,
17th of July, like that.
Lordship, can kindly give me for a clarification?
It's okay, it's okay.
Lordship.
It's okay. So that is the explanation.
The-
Why 17 came, because it
Yes,
was
yes.
published on 17th.
Yes, Lordship. So that's why in the corrigendum, they have stated as 17 July 2020, the day which was published in the newspaper. 16 July was the department's advertisement.
Okay, that is one thing you have challenged, the corrigendum.
Yes.
What is it, number 2? This also is like, there's some mistake. Come to page 24 of your prayer
24.
portion. Numbering is also wrong. From A it goes to D. A, D, B, C. Isn't it?
A is impugn corrigendum in respect of clause C.
That's page 36.
Yes, page 36.
Next-
annexure
next
E1.
is- next-
Next is impugn letter dated 4/10/2022.
It should be B, isn't it? You have put
Oh,
you have put D.
I beg your
instead.
pardon, I beg your pardon, Lordship. True.
Impugn letter dated 410. What is this 410?
410 is annexure M, 109. Page 109, Lordship. This is Director of Health and Family Welfare Nagaland communicating to the Principal Secretary to the Government of Nagaland, proposal for special recruitment drive through NPSC. This is under challenge. Shall I read out, Lordship? Or
Yes, just read.
proposal for special recruitment drive through NPSC. In inviting a reference to notification number so and so dated 26 June 2020, dated 2nd July 2020, and dated 5th July 2020, and memorandum number so and so 12 June 2020, and dated 25th June 2020. Recruitment for the newly created post in 2021. List of newly created posts which comes under the purview of the NPSC in Annexure 1 will be through a special recruitment drive by NPSC as one-time special dispensation for relaxation of laid down rules and procedure for recruitment, regularization and condonation of age in view of the prevailing situation in the backdrop of COVID-19 pandemic. Therefore, for recruitment of regular appointment to the newly created post, detailed enclosed at Annexure 1, the government may consider the following modalities for conducting the special recruitment drive by the NPC, which had already taken place. But therefore, for recruitment of regular appointment to the newly created post, detailed enclosed, the government may consider the following modalities for conducting special recruitment drive by NPSC. 1, condonation of age up to 45 years for contractual employees and the state government, such as NHM, NSACs, NHAK, BSL, LAB, etc. 2, weightage up to 25% of the total marks depending on the marks obtained by the candidate in the qualifying degree of the university medical college. 3, work experience weightage up to 25% of the total marks depending on the length of service rendered by the contractual employees of the state government, such as NHM, NSACs, NHAK, BSI, LAB, etc. Bonus point up to 25% of the total marks depending on the length of COVID duties rendered in the government or private COVID facilities for at least 100 days in accordance with condition laid down by the government letter number so and so dated 22nd May 2021. 5, the total weightage on account of serial number 2, 3, and 4 shall not exceed a total of 50% of the total marks. The existing reservation policy will be followed wherever applicable. So here, the grievances of the petitioner is special recruitment has already taken place. And in a general NPSC recruitment, the highest recruiting body, how can this special recruitment providing 50% to other candidates, whether in service or new candidates, Lordship? They are planning to have a special recruitment through NPSC. Whereas even after 45 years of relaxation, not admitting, but even assuming, Lordship, the petitioners have already crossed 45 years of age because they have appointed since 2005, Lordship. And they left their job because the respondent promised that it is a regular appointment. That's why they resigned from their previous post, and now if they appear NPSC, they are over age as well as, Lordship, that can never be. They cannot, the recruitment has to go as per the advertisement, Lordship. They cannot change the rules of game.
Okay, you were appointed under the NHM on contract basis.
Yes, Lordship.
Then the department issued an advertisement.
Lordship.
This recruitment was supposed to be done by the department.
Yes,
on regular basis.
recruitment board.
And you were appointed as such, but not as a regular appointee.
Opposed to
Then
their advertisement.
the post is of staff nurse, isn't it?
Yes, Lordship.
Staff nurse, what is the normal recruitment done by whom normally?
There was no recruitment as such, as the learned government advocate has placed before this honorable court. Advertisement in the 1988 service rule is there, Lordship.
What does it say? Recruitment through what?
Through NPSC.
NPSC.
Yes, but not even once have they conducted recruitment through NPSC. And as he has explained before this honorable court, illegally they have been doing that through queue system.
Queue system.
Yes.
And now
And this
they
is the first
say
time.
it's because of the COVID pandemic, due to urgency,
Lordship,
they're doing such kind of recruitment.
Lordship,
Otherwise, as per the recruitment rules, it is through the NPSC.
as that is admitted fact.
Okay.
However, not even once had, since 1988, when the service rule came in force, not even one recruitment has been done through NPSC. And the nurses has been recruited as per queue system. And we are the first batch. We, the petitioners, are the first batch who have been recruited through advertisement.
No, advertisement, but it is not queue system.
No.
What was the criteria for selection then?
Criteria for selection is on merit.
Merit in the sense, like, was
Merit
there any,
basis. Through previous education,
was there any written test? Was there any interview?
written test was not there because during COVID time, there was a lockdown all over the state, Lordship. So due to emergency, it was done through Zoom interview.
Zoom interview.
Yes, in consideration with previous education qualification marks as well as their performance in the interview.
And experience also.
And experiences, Lordship. So, my lord, will kindly come to, I want to start with.
So basically what you're saying is that advertisement was for direct recruitment.
Yes, Lordship, exactly, special
for
recruitment.
Special recruitment on regular basis.
Yes, Lordship.
Instead, they have gone for recruitment on temporary basis.
Yes.
And now they are telling us the recruitment will be done through NPSC.
Yes, Lordship. And my lord, this cannot be, Lordship will kindly come to this.
No,
This
is there any other advertisement again after
No.
your recruitment?
No. This honorable court, we challenge that, and this honorable court by order dated 6/12/2022 has stayed the notification dated 2/11/2022. So far as it concerned, the 129 vacancies of staff nurse shall remain suspended.
211, which one? What is that document?
In the
No,
same case.
in the same case,
She's
in the
talking
same
about
case.
the stay order.
Stay order.
Stay order in this
It
case.
has been stayed.
No, what document has been stayed? That's what I'm asking.
211, Lordship.
Where is 211?
211 is 126, next year R. Page 126, next year R, Lordship. May I read out, Lordship? Notification dated Kohima the 2nd November 2022. In the interest of public service and on the approval of the cabinet by the number so and so dated 26/5/2022, the governor of Nagaland is pleased to notify the following posts to be recruited through a special recruitment drive as indicated below. So ours is at serial number 7, Lordship. So these are the 24 petitioners. 124 petitioner before the Honorable Court. So staff nurse 129, class 3 non-gazetted, level 8 NPSC. So this was issued by the respondent. So we approached this Honorable Court and it has been stayed in the interim, Lordship, in respect of the staff nurse. Now, my Lord will kindly, in order to have a clear picture, Lordship, will kindly come to page 36. This is the crux where the petitioners are bring before the Honorable Court. This corrigendum was never published in the newspaper.
Where is that?
Page 36. E. It was done behind the veil. And now they want to impose this upon the petitioners. It was never published in the newspaper, hidden, and this is in violation of principle of natural justice against the petitioners, Lordship. Now, C. Above are for other doctors and laboratory technicians, but C. Here we have been included regular appointment in case of OT technicians, ECG technicians, laboratory technicians, radiographers, ray technicians, and staff nurse to be read as temporary appointment. The advertisement, this is duping, this is defrauding the petitioners. They said regular appointment and advertise as regular appointment when there is no even regular appointees who were resigning from service. They want our service. I have annexed even the test results also of the petitioners, Lordship. Those who got positive and were hospitalized were in ICU. So when other left the job, since it was a regular appointment, we resigned from our previous job and appeared this examination. Now, by this corrigendum, they turned our regular service into temporary appointment. Temporary appointment. Now, Lordship, D. This.
You resigned before appearing for the interview.
Lordship.
Why?
Because we want, since we were assured that it was a regular appointment, we were contract appointees. So anybody will want regular service, Lordship. That I don't have to say, my Lord.
No, you could have resigned after being selected.
Yes, Lordship. So
because the terms and conditions for applying the post does not say that you have to resign first, then only you can apply. Isn't it?
it does not, it did not say, but those who want to apply for it has to resign, Lordship.
How? Why?
Lordship, with even if contract appointment, we cannot hold two posts.
No, you're not holding two posts, you're applying for it only. See, a person who has participated, let's say, for example, in a combined competitive examination, Nagaland Civil Service, Nagaland Police Service, maybe Nagaland Finance and Account Service, or something like that. Supposing he wants to become a civil servant, NCS, or what do you call it? NCS is there, isn't it? Civil
Lordship,
service.
Civil NCS. It
NCS.
is appointment post. It is called NPSC. Yes, NCS are
NCS.
those who pass from
Correct.
NPSC.
So supposing this person, because of his merit, he's get police service instead, NPS. And he wants to try for the NCS. He can again sit for the exams. He does not have to resign from the post of NPS and then sit for the NCS examination like that.
Lordship, I have.
So that is why in your case also, there was nowhere in the advertisement which says that you must resign. If you want to apply for this post, you must resign first. Then only you're eligible. It doesn't say so. You can apply, and if you are selected, then you have to choose either of that. Either you want to remain under the NHM or you want to go for the other post. Like that.
Lordship, I can clarify that, but after we were selected, after the petitioners were selected through this advertisement, we resigned from the previous post.
That is a different thing. You were saying that first you resigned, then you appeared for the test.
Some did that, but Lordship, I beg your pardon. I have to confirm that. However, I have annexed even their resignation from the post letter also in my annexed chair. Anyway,
see,
Lordship, just for this clarification of this portion, I will come to that.
after being selected, if you resign, it's okay. You have made your choice. But even before you are selected, why should you resign from the earlier post? You are very 100% sure that you'll be appointed. That's why you resign.
No, Lordship. I beg your pardon, Lordship. After our selection, we presumably we resigned. Lordship, I have annexed their resignation letter also in the annexed chairs.
Anyway, it's okay. I'll take it from you that you resigned
But
because
whatever, Lordship, since it was a regular appointment, we resigned from our previous post. That is admitted fact. So from
that also another thing is that you see, you resigning also, again, it's up to you. See, your appointment order at page 102 says that you're engaged only for 12 months. Why should you resign after getting that appointment order? Because as it is, you are also holding a contract appointment for 1 year under the NHRM.
Lordship, by that time, we have all resigned from our previous service.
But why did you resign?
Otherwise, my lord didn't want to intrude into our psyche. The post was assured and say that it is a regular advertisement. That's why who doesn't want to have a regular advertisement after 16, 17 years on contract? So
But
after we were selected.
Where is the guarantee that you will be selected and appointed?
No, after we were selected. After we were selected.
No, it can be either one of them. It cannot be both. Whether you resign before your appointment or whether you resign before you are selected. You resign before you're selected or after you were selected. Which one? It cannot be both. Because if you say that I resigned after I was selected,
After we were selected.
then another question is, why did you resign? If you see your appointment order, it says you're appointed only for 12 months. You're jumping from one temporary post to another temporary post.
Lordship, here, my lord will kindly bear with me. I am challenging this. I am challenging this regular appointment that was turned into temporary appointment. That is annexure C.
See, I want to see your statement. What exactly have you stated in your petition about your resignation? Let us. When did you resign? Under what circumstances you resigned? You must have stated somewhere.
Yes, yes, Lordship.
Let us see.
Give me 1 minute. Just give me some time, Lordship.
I don't think there's any statement.
Lordship, no, somewhere I have stated Lordship. Just kindly bear with me.
In your paragraph 12, you have stated that when the successful candidates was announced, you were shocked to see the terms and conditions of
The
appointment.
petitioner continued their contract service under the NHM, performing general duties, risking their lives, taking care of the COVID victims at a time when even the family members were not allowed to come near the patients, and consequently, many petitioners were infected and declared COVID positive and had to undergo weeks of quarantine, of which samples of positive result of some petitioners are substantiated. In person to the interview held on 19/12/2020, the respondents selected 129 successful candidates, and by common order bearing number so and so dated 15th April 2020, the 124 petitioners were appointed. However, the petitioner were shocked and surprised when they saw the terms and condition of their appointment order absolutely contradicting the advertisement dated 16/7/2020 issued in the local dailies, inviting applications for.
Okay, please stop there. If you were shocked and surprised, why did you resign? You were working in NHM under the same condition for 1 year, which is again renewed again for 1 year like that. That means you resigned.
Yes, we resigned.
Prior to your selection, you resigned. It doesn't make any sense. Why should you resign from your appointed post? Because the terms and conditions does not stipulate anywhere that if you want to apply, you first have to resign. It does not say anything like that. On your own free will, you resign. So that is the situation. But of course, on the other hand, your other argument also that remains, that this is the advertisement and this is the appointment order. It does not tally. They have changed the rules of the game. That will remain, no doubt. But your conduct, I'm surprised about your conduct. Just because one advertisement has come, you resign your post. Quickly you resign.
Lordship, this NHM also comes under medical department supervision. So during COVID time, it's not like the present time where one can interact or one can talk with the department or approach the department. So they were informed that a regular post will be advertised for regular appointment for those who apply for the post during COVID time. So just on the enthusiasm of always having worked as contract employees without regular employment, the petitioners, not only the petitioners, thousands, those who were working in private clinic, those who were working under NHRM, many resigned. Some did not apply because even regular appointees were submitting their resignation. So in that kind of situation, emergency, where Lordship, extraordinary situation demands extraordinary remedies, and in order to have regular appointment, extreme circumstances, extreme measures, we applied for the post since it was regular advertisement.
That's okay, you applied, it's good. You applied for regular post. But doesn't mean that you abandon your contract post even before you are selected. Where is the guarantee, 100% guarantee that you apply, you will be selected? You yourself resign. On the contrary, the page 33 terms and conditions of the advertisement says that those who have resigned from contractual service without valid reasons will be disqualified. In fact, they don't want people to resign also. If you,
No,
if you
Lordship, there are
resign,
some-
if you resign, there has to be a valid reason. Because your services are required, because people were escaping. I will contact COVID, so I don't want to work as a nurse. They were abandoning their post. And those who were remaining on their post, they were given the benefit, the relaxation, all that sort of thing. That was the spirit, I think. If you see the eligibility criteria, those who have resigned from contract service without any valid reason during the COVID-19 pandemic crisis shall not be eligible to apply for this recruitment drive. So those who remain firm on their duty, they were given the chance. Those who just escaped saying that I'm not joining and remained silent,
Lordship,
they were
this
disqualified.
one, terms and condition, this one, if my,
And here you say that you have resigned, but where is your resignation? We don't know.
no, that's why
Resignation
I will, resignation letter, Lordship, I have resignation letter. Kindly allow me to peruse, Lordship. I have annexed. So many,
But anyway, that is not the main issue. I know that's not the main issue, but since you have raised it, that's why I'm just trying to find out what was the thing
that's why
behind.
I'm saying that I can clarify from my clients whether they resign before or after. That is not an issue. Even me, I was thinking that since that was not an issue, I may be given some time to clarify. That by tomorrow I can
Surely.
submit before the Honorable Court. However, Lordship, my main challenge is this: they did not publish, they did not, without the knowledge of the petitioner, they changed the circumstances of the advertisement, conditions of the advertisement
Behind your back.
behind our back.
They issued an advertisement for permanent post.
Yes, and
Later
behind
on-
our back.
Later on, they made it a temporary post by saying that we have issued corrigendum.
Yes, but that was never issued.
But in fact, corrigendum was never issued
Issued,
publicly. We never know about it.
Exactly, Lordship.
That is your case.
Exactly, Lordship. And in the seniority list, Lordship will kindly, in the seniority from again temporary appointment, our appointment letter, even not admitting, but even presuming, even if NPSC appoint through selection, the order of the appointment always carries temporary appointment. No appointment carries that is a regular appointment, not admitting, but even presuming, Lordship. So to us, even if it is not a regular appointment, temporary appointment, that means regular appointment. So that was not an issue with us, temporary appointment, because even NPSC, all selection, all competitive exam selection that was advertised and appointment are issued, carries temporary appointment.
But this appointment order is different.
That
Page 102, see, it's different. I know for sure, any appointment, whether it be NPSC or whether it be UPSC, it says that so-and-so is temporarily appointed to the
Yes,
post of
Lordship.
so-and-so.
Exactly,
Okay, subject to finishing completion of the probation period, whatnot, subject to police verification, all those things are there. But in your case, if you notice, it says your appointment is for a period of 12 months. Till regular appointment is made through NPSC. It says that.
But is it in tune with the
It's not in
advertisement,
tune.
Lordship?
It's not in tune. So on that day itself, you could have got the signal that this is a different appointment. Why should you resign?
Lordship, I have stated before, just over the phone, over the WhatsApp. Otherwise, even this appointment order was sent through WhatsApp after they were posted.
Where is your statement? that I have not received appointment order. It was given by WhatsApp, which I came to know much later on. Have you made a statement?
Lordship,
These are required, you see, you cannot,
Yes,
you
Lordship,
cannot add or minus your submissions like that. So that the other side can get the chance to rebut that. If they don't, if
Lordship,
they
that I
remain
will-
quiet, that means they also accept that you have sent by WhatsApp.
Then my lord, kindly bear with me patiently and let me go through my submission portion. I
We'll do one thing, we'll take it up again some other day. You prepare and come.
As far as the state is concerned, the respondents, Lordship, we are very clear because they have not used the second cabinet memorandum where it has been specifically stated that the appointment will be temporary in nature. In my affidavit, I have annexed.
So giving us temporary appointment, that
one.
is not an issue.
Before the advertisement was issued, Lordship, the dates are very important, Lordship. I'm saying the dates are important is the sequence of event that has happened, Lordship. There were two cabinet sittings, Lordship. On 6th June 2020, which they have used in the writ petition, Lordship, and 25th June 2020, where the cabinet reviewed its own decision, where cabinet said in clause B, the department should clearly.
25th June?
Yes.
Where is that?
It's in my affidavit. They have not used.
Page?
Page 17 of my affidavit, Lordship. Lordship, may kindly see the cabinet memorandum. The 78 post creation in it, Lordship.
20 page?
Page 17, 17.
Oh, 17.
State, yes, respondent number 3 and 4. Lordship, may kindly see this is cabinet memorandum 25th June 2020. Lordship has found?
Yes.
Lordship, our concern is serial number 5, creation of 78 posts. On 5th June, 143 posts, Lordship. Now 78 staff nurse. So total comes to 221. Then there were 37 resultant vacancy. That's how 19 was added by the addendum, Lordship.
No, that is okay.
Yes.
Where is the cabinet memorandum said that it will be filled up
Page 18.
on temporary basis?
Next page, 18. Clause B. Clause A, starting from clause A, Lordship. All the newly created posts should be filled by the HM, Head and Family Welfare Department within a month's time with proper advertisement. Lordship, this is very important. With proper advertisement. While filling up the post, due weightage should be given to these are conditions. B. The department should clearly indicate that this appointment will be temporary and regular recruitment shall be conducted through special NPC recruitment drive. Now, on 5th July, this is 25th June. Lordship.
What is the purpose of having this recruitment again and again?
No, Lordship, that was a cabinet decision. Because this post falls under the purview of NPSC. Lordship,
then why don't you wait for the NPSC instead of making temporary recruitment first, then making them wait for another recruitment drive second time?
Lordship, this was during the COVID time.
That's why special recruitment took place, Lordship. Why the second recruitment? And petitioner cannot now appear. We are all of over age. Most of the petitioners are
Lordship.
crossing 50.
No, Lordship. The ADNA has come before the court. Now the court has come down up to 45 years.
I have annexed those who have crossed 45, Lordship.
Now, Lordship, the sequence event on 5th July, after this cabinet memorandum was issued. 5th July, Lordship will find it in the writ petition.
Mr. Mozui, simple question is that if you are saying that this has to be through the NPSC, why don't you wait for the NPSC recruitment?
That's what we have sent to the NPSC for special recruitment drive, which is under challenge, and this has been stated by this court.
Because we have already been recruited,
No,
Lordship.
they have been recruited by the earlier advertisement.
Yes.
But not through NPSC, Lordship.
I know. So why do you have the first recruitment without NPSC, second recruitment through NPSC?
No, Lordship.
Twice?
Under clause A. Clause A says the department should do the recruitment within 1 month time. That was the emergent need of the medical personnel. If not only staff nurse, even medical officers.
Please clarify that. Where is it written like that?
Lordship, may kindly come to clause A.
Due to the emergency situation, we have to organize and recruit somebody till regular appointment is made by the NPSC.
Lordship, may kindly come to page 17. Let me read from the beginning, Lordship. agenda number so and so, recruitment of doctors, nurses, and other paramedical staff in the health and welfare department.
Where? Page 17?
Page 17,
Okay,
yes.
yes.
Agenda. The Health and Family Welfare Department submitted a comprehensive proposal for creation of posts. The department presented the manpower status indicating existing regular and contractual manpower as compared to the norms of the Indian Public Health Standard. The cabinet deliberated the matter in the backdrop of the unprecedented situation arising out of the COVID-19 pandemic and the need to address the inadequacies of the state health system, including shortage of manpower at requisite level. After detailed deliberation, the cabinet approved creation of the following posts in the Department of Health and Family Welfare Department. So these are the posts created. The emergent situation that was prevailing at that point of time, Lordship. Now the next page, Lordship. The cabinet further directed that. Now this is a policy decision of the government, Lordship. A, all the newly created posts should be filled up by the Health and Family Welfare Department within a month's time with proper advertisement. Lordship, if it has to go through NPSC, Lordship, a proper advertisement has to be issued through the Public Service. We have to send the requisition to the Public Service Commission. Public Service Commission will sort out. Lordship will take even a year.
Where is the memorandum as per se? This is only an abstract, isn't it?
Yes. Now,
do you have the memorandum with you? The entire memorandum, cabinet memorandum?
No, Lordship, I don't have.
It does not say so in many words.
Yes.
That due to the prevailing pandemic and emergent situation, people have to be recruited
No, Lordship,
within.
this cabinet sitting was held only for this purpose.
Maybe, but it does not explain like that. Now, you are trying to submit that it is understood that if it goes through the NPSC, it will take months and months, maybe years to do the recruitment.
Gotcha.
But that picture has to be presented by the cabinet also, that if we go through the NPSC, it's going to take time. The rules of 1988, isn't it?
Yes.
Provides for NPSC recruitment because it's a gazetted post.
Lordship, no doubt, Lordship, appreciating what Lordship has pointed out, Lordship. But the reading of the memorandum itself shows that, Lordship.
No,
The
otherwise,
department
see,
cannot-
otherwise it means that first we'll appoint these people through the department for some time. Next thing we'll do, we'll make a recruitment through the NPSC. So these people are sitting for one exam and second exams also. Not exams, maybe test, maybe interview, whatever.
More or less.
So it's like two process of recruitment. They have to undergo two process of recruitment. Why? That is the question.
Lordship,
Lordship.
Recruitment has happened for different categories. Medical officers, Ayush doctors, dental doctors, technicians.
No, we're concerned with staff nurse. Forget about others.
Yes, Lordship.
Lordship, what I'm trying to say is, it's not only staff nurse. What I'm saying is, it's with other posts also.
Other
No,
posts did not apply, Lordship, and they were accepted.
Others got appointed on temporary basis. They have accepted, and they are waiting for recruitment to NPSC. They're waiting for recruitment to NPSC.
But that is not an explanation.
No,
No.
Lordship.
Some have accepted, some have not accepted.
No, Lordship. That's
Why should they not accept when others have
Lordship,
accepted? You cannot
yes.
apply
Let
that
other
logic.
posts bring before this honorable court because other did not apply and they were just taken over without interview, Lordship. Our case is different. We have approached this honorable court and the
Lordship.
advertisement was as per they did not challenge it. And as per the advertisement, the honorable court directed and that advertisement has gone through the process of law. Because in the first writ petition, they did not bring up any issue about this, Lordship.
Lordship, may I kindly appreciate the petitioners.
Why are they trying to twist in turn, Lordship?
The petitioners.
Victimizing the petitioner's life?
It's difficult to get two councils at a time.
The petitioners have not challenged the appointment order, knowing that very fact that it's in temporary nature, Lordship. Now, Lordship, how it came as a temporary nature, Lordship? It's because of this cabinet decision. And Lordship, in the writ petition.
They cannot do that illegally.
And Annexure C, page 30, guideline has been framed. My learned friend has conveniently skipped this. This is where the whole game started, Lordship. Lordship, may kindly see Annexure C, page 30 of the writ petition. Why this recruitment was done, Lordship? The explanation, Lordship, which Lordship was asking, it's there in the writ petition. In the writ petition, Lordship.
Page?
Page 30 in the writ petition.
30.
30, yes.
If I have annexed, why I
You have skipped, that's why.
30.
Just trying to show. Page 30, 30, annexure C. Lordship, why I'm saying the dates are very important.
What is this?
This is notification dated 5th July 2020. On the recommendation of the cabinet by cabinet number so-and-so dated 25th June 2020, which I referred to, Lordship. The governor of Nagaland is pleased to frame the following basic guidelines for recruitment and service condition of the medical officers, nurses, technicians, and other paramedical staff as under. A guideline was framed.
It is in the direct petition. Where is the question of hiding?
I'm
Don't
not
mislead
saying
the
hiding,
court.
I'm saying you have skipped. So guideline was framed.
Okay, what is the relevant guideline here?
Yes.
Which one?
One is again the reiteration of the cabinet A and B, Lordship, 1 and 2. All the newly created posts to be filled up by the Health and Family Welfare Department within a month's time and with proper advertisement. While filling up the post, due weightage should be given to so-and-so, so-and-so, so-and-so. 2, this appointment will be temporary, fixed, and regular recruitment shall be conducted through a special NPSC recruitment drive for all posts coming under the preview of NPSC. A guideline was framed. It's the on document, Lordship. I'm reading the on document.
No, guidelines for how long? This is not their own document. This is your document. Health and
Yes.
Family Welfare Department.
Yes. So the advertisement, when the advertisement was issued, Lordship.
No. These guidelines will remain in force for how long? You already have the 1988
Yes.
rules.
Yes, Lordship.
Which provides that recruitment is only through the NPSC.
Yes.
Yet you go for the queue system.
Yes, exactly, Lordship.
Now, why these guidelines have been framed? For what purpose? That's why I'd
Yes.
ask you, why not you bring the entire cabinet memorandum? Is there anything more in detail? Because like you said, it was due to the COVID pandemic that this step had to be taken. I understand. Government has every right to do that for the public interest, since the recruitment will take almost 1 year or 6 months, 8 months. Till such recruitment is done on regular basis, we need to appoint somebody to work on the field. So that therefore, within 1 month, some appointment should be done, but that should be done as per advertisement. So if that thing is there, you show it to us. Otherwise, why should you undertake 2 processes of recruitment?
Exactly,
That is what I'm
Lordship.
saying.
Lordship.
You invite somebody for dinner.
Lordship.
First, you serve him vegetarian food. You wait for 2 hours. I'll give you non-vegetarian later on. Can you do that?
Lordship.
Otherwise, you can tell him, wait for 2 hours. We are preparing. We'll prepare the entire meal. You'll have
Your
everything.
Lordship, appreciating your Lordship's
Isn't it?
concern with that.
Now, why have you taken this step of recruiting somebody within 1 month?
Duping somebody.
And later on,
That is as per the cabinet decision, Lordship.
maybe cabinet
not
decision is
alpha and omega. Illegal.
is also has to be examined. They have to justify also, isn't it?
Not Lordship, as far as.
Because this has caused some hardship here.
Yes.
There were some people
Understood.
who wanted to have
Understood,
regular
Lordship.
recruitment.
We accept that. We understand the pain that the petitioners have gone through. But when the cabinet is giving us direction, when the government policy, they are making a policy at the highest level and giving direction to us, Lordship. We are there to implement it, not to question the cabinet.
Lordship.
And very
All
interesting-
this,
Ms. Zimam, just take your seat. Let him finish.
Lordship.
Anyway, we are not completing this hearing today, since you have to clarify something also, isn't it?
Yes, yes, Lordship.
Now, Lordship, knowing the very fact that the second cabinet memorandum, 25th June, speaks against them, Lordship. Clause B, more particularly.
Okay, that you have seen. Where is that 6th June, by the way?
Lordship?
You said there are 2 cabinet memos.
Yes, the first cabinet memorandum is in the
6th June.
in the read petition.
6th June.
Yes. Sorry, 12th June. Sorry.
12th June.
12th June. 12th June.
Where is that?
Annexure A1, page 26 of the read petition. This is the first cabinet decision. There was a separate cabinet sitting for this COVID. And actually A1 Lordship has found.
Yes, what does it
Page
say?
26. Serial number 5, creation of 143 posts of staff nurse. So 143 here on the 25th June.
How it is to be recruited? How are they to be recruited?
Sorry, it's 12 June. Lordship, 12 June.
The cabinet also approved for appointment on the existing system of the nurses while ensuring judicious deployment in just and fair manner. What do you mean by existing system?
Queue system, Lordship. They are twisting and turning everything, Lordship.
Lordship, this was brought to the notice of the cabinet that in spite of having a service rule, the department has been recruiting through queue system. This was brought to the notice of the cabinet. So, Lordship, in my affidavit, the document, the queue system, I'll explain, Lordship. Lordship, may kindly come to page 18 of my affidavit. Page 18 of my affidavit. The queue. That's why these two cabinet memorandum has to be read for jointly, Lordship. So this was reviewed again. Clause E, Lordship as found, clause E, page 18 of my affidavit.
Yes.
For the post of staff nurse, and as per the recommendation of the Manpower Rationalization Committee, MRC, the department should fill up 50% of posts of staff nurse from the queue of former nursing diploma graduates, and the remaining 50 should be filled up through direct recruitment and open competition. For direct recruitment posts, the existing reservation of posts of the backward tribe shall be followed wherever applicable.
This is from which decision?
The cabinet decision.
25th.
25th, yes.
25th June.
Yes, 25th June. And the one Lordship has read out is the 12th June, Lordship.
12th June says that existing system.
Q has approved.
So it's 100% Q system.
Yeah, 100%.
Now, as per this 25th of June.
They have reviewed
50-50.
Yeah, 50-50, and which this honorable court has upheld as a one-time measure.
No, Lordship, that is misleading.
My friend
Lordship,
can like
the judgment order is very clear. Queue system is unconstitutional and declared
But
unconstitutional.
the court is not inclined to interfere into the notification and the decision of the government.
Then how can the advertisement that went through the judicial review of the court be again questioned before this honorable court? The advertisement, Lordship, that is the issue here.
Lordship, as Lordship has pointed out, paragraph, page 75, the last paragraph.
75 of?
The read petition. As such, Lordship has found.
Yes.
I find now nothing illegal in the impugn notification, that is the post creation. And the impugn advertisement, in particular, in any case, as stated above, the validity of the second part of the case of the petitioner depended on the result of the finding made in the first part. Because when it has been decided that in the first part of the petitioner's case that appointment through custom is not within the constitutional scheme, appointment to the post of 143 staff nurse created by the decision of the first cabinet meeting on 11/6/2020 could not have been followed throughout the queue system alone. So this honorable court has decided not to interfere because this is a one-time measure. So the second cabinet memo was upheld. No, they have not challenged this order. Nobody has challenged this order. The petitioners were part of this writ petition. Next line. Furthermore, from the reading of the minutes of the two cabinet meeting and the notification issued thereafter, it appears that it is an emergency and one-time measure taken to deal with the health issues of the people of the state arising out of the COVID-19 spread. Therefore, the court has no inclination to interfere with it.
Interfere with what?
The cabinet decision, the notifications.
And the advertisement, Lordship. advertisement.
The advertisement that will come later, but that has been corrected by way of original. So the two cabinet decisions and the further notification and advertisement. So the court has not interfered with it because this is a one-time measure and nobody has challenged this.
What is the date of the notification?
Notifications are dated, Lordship, the post creation, 26th June and 2nd July and 5th July. Annexure B, B1 and C of the writ petition.
Where's 5th July?
July, 5th July is at page 30, Annexure C. The guidelines. These were all under challenge in the earlier writ petitions.
Cabinet decision was
Lordship,
23rd of
25th. 25th of June. Decision meeting was held on 23rd June, but the memorandum was issued on 25th June 2020.
Where's that 23rd?
Annexure 1, page 17 of my affidavit.
Yes, correct. So you say that it was a one-time measure, court
Yes.
did not interfere.
Yes, the court said
It was a part of the
yes.
pleadings and challenge made in that writ petition.
Yes, even the petitioners, the association, they accepted. They accepted.
We accepted because we challenged the advertisement, Lordship.
Now,
Why speaking two ways, in and out? They are saying in one way it is in administrative exigency, whereas on the other hand, Lordship, all these cabinet memos and these things were before, prior to the advertisement, Lordship, in your wisdom knows.
Now, thereafter,
If-
Lordship, the advertisement was issued on 16th July. And the advertisement issue, who issued the advertisement, Lordship? The Lordship may kindly come to page 32 of the writ petition, 16th July. Page 32. Page 32 of the writ petition, Lordship. The principal director.
Yes.
The advertisement, Lordship. Immediately on coming of this, the government asked the department why this has been issued on regular basis when the cabinet decision is on temporary basis. So accordingly, the corrigendum was issued by the same authority again.
But why didn't you circulate that?
Lordship, it was uploaded in the website. We had a website, Lordship. The applicants, the candidates were directed to download all the information from the website.
Where is your statement?
Lordship, we have not made a categorical statement, but it has, Lordship may kindly see in the corrigendum. Copy to the director IPR, Department for Wide Publicity. Automatically, as far as the department is concerned, Lordship is uploaded in the website.
Lordship, newspaper publication is official, and all other corrigendums they issued in the daily newspaper.
Lordship may kindly come to page 36.
They are trying to. Advertisement.
If the petitioner counsel has something to say, let her finish. After that, I'll start. Lordship.
You have not replied.
We have not made a categorical statement, Lordship.
Mr. Mozui,
Lordship.
petitioner has made a categorical statement saying that corrigendum was never published. You have not said anything.
Yes, Lordship, that I don't deny that fact, Lordship. Now, Lordship,
So then what will happen then?
Now, Lordship, when the appointment orders was issued, because the guidelines were framed on 5th July, Annexure C of the repetition, that this will be temporary in nature. All the posts that comes under the preview of NTSC will be temporary in nature. They are aware of it.
So that is why director issued the advertisement.
Lordship.
It is temporary in nature. That is why the director issued the advertisement.
Yes.
Only thing is that instead of saying temporary, he started using permanent. Immediately, you could have rectified that.
Lordship, the directorate, the principal directorate and the directorate level has issued the advertisement, Lordship. Now, this has come to the notice of the government. Government has directed, no, this is not to be on regular basis.
Correct. But your corrigendum was not publicized.
Lordship, it was given to the director IPR for wide publicity.
How do we know it he has published?
That
Where has he published?
Lordship, that I'll leave it to your Lordship.
No, don't leave it to me.
Yes.
If you want to withdraw your advertisement, which was wrongly coined, you should have publicized that we made a mistake. This is the corrigendum. It is not permanent post, it is temporary post. You could have done that.
However, Lordship, when the appointment orders were issued, it has been specifically stated that this appointment are temporary in nature. They have accepted it. And they are saying, we have changed the rule of the game.
They have accepted what?
They are saying that we have changed the rule of the game after the game has been played, after the recruitment has been done. No, it's not a question of that, Lordship. There's already a cabinet decision. There's already a notification where it clearly said that this are all temporary in nature, the recruitment. We have not changed the rule of the game, Lordship.
No, cabinet decision, guidelines, all says temporary. Okay, fine.
But
your advertisement says permanent.
Lordship.
And you come up saying that we have made a corrigendum. But when asked, where did you publish? You say that we have given it to Director INPR. Director INPR must have kept it in his drawer. We don't know. Petitioner has specifically said that it was not advertised. I mean, it was not publicized. You have chosen to remain quiet. That means you admit that it was not publicized.
Now, Lordship, under what circumstances, Lordship, the petitioners are saying that this appointment is regular in nature? What about their own appointment order, Lordship? They have no challenge their own appointment order. Lordship, and under what power of this court, Lordship? Can the court regularize the service?
No, they should challenge their own appointment order.
Because it says temporary. Whether the court can change the terms and condition of the appointment order, Lordship?
No. Whether you can change the advertisement.
Yes, exactly, Lordship. They are
You
contradicting
you
themselves.
say something, one thing, one in advertisement, you give them something else in the appointment order.
Exactly, Lordship.
That question also has to be looked into. Now, both of you have their own points.
Yes.
Now, you should have challenged your appointment order also insofar as it relates to temporary appointment.
Yes, they have to.
Lordship, we are beggars before this honorable court. We were appointed, beggars have no choice. How can we were given contract, we were on contractual basis for survival under Article 321 for survival. Now, Lordship, advertisement was regular appointment, so we appear for the advertisement because it is regular appointment. Now they have twisted everything. They have made U-turn and now they have this was never even in the portal, Lordship. That they can twist each and everything to their own convenience,
Okay.
Lordship. But we are poor.
As on today, where are you? You're still appointed on that temporary basis, isn't it?
Yes, Lordship. We
Extended.
are getting
And,
regular pay.
Insofar as the fresh recruitment drive has been sought to be initiated, by which annexure? By annexure R. Isn't it?
R,
Yes.
This has been stayed.
Yes.
State.
Insofar as staff nurses concerned.
Yes, only staff nurses, Lordship.
As far as this case is concerned, there are other cases also. Dental doctors are here, Lordship. Ayush doctors are here.
Okay.
OT technician, ECG technician. There are 5 category of posts.
Oh, they have filed cases also?
Yes.
Similar to the present one?
Yes, yes.
Okay.
Our case is different, Lordship.
No, they are the same boat.
Lordship, advertisement here, it is all the same, but the fact of the case and circumstances, our case is different.
No.
We are those who were in service for 16, 17 years under NHRM, Lordship. And because they advertise for regular appointment, we joined this second service. And Lordship,
They have not
yes,
changed.
I
the-
have.
They have not changed the boat. They have just changed the seat. In the same boat, they have just changed the seat.
And Lordship, as I have already stated before this honorable court, after the judgment order, our judgment order was passed, they have, in December, they have appointed 29 through queue system again, in violation of the first judgment order. Instead of us who were recruited through advertisement as per law.
But you're not challenged that 29 appointment, isn't it? You're not
Because that is
challenged-
a different post.
that's
That
why.
is also a vacancy.
That's why.
And ours, 129, they want to send it to the NPSC. It is a regular appointment, so our posts are regular recruitment. Lordship, I pray this honorable court that, and in my affidavit in opposition, I have seniority list is there. I have annexed in my affidavit in reply to your affidavit in opposition. Advertise seniority list of staff nurse in the department. My lord will kindly see that this is very tricky. The first, after the judgment order, the first 129, those who have been appointed as per queue system in violation of this honorable court, declaring it as unconstitutional and illegal queue system. They still went ahead and giving us this stepmotherly treatment. They gave them regular appointment, temporary appointment, regular appointment, as per previous practice.
But nobody has come and brought that to the notice of the court, that the direction was to not to appoint through queue system, but still they're making queue system.
But still then we are before this honorable court. I have
Nobody has
stated in-
come. You have come against that particular advertisement. You're not against the appointment of those people.
That was after the direction of the court.
Correct.
Lordship.
You're not challenging their appointment.
Yeah, we are not. We are on our
So
post.
we'll not travel beyond the pleadings.
Lordship.
We'll restrict ourselves to what is here before us.
If that is my Lord desire, Lordship, I submit
Because
to
if
it.
you were affected, you could have very well brought that to the notice of the
But
court.
just since it is in co-related, Lordship, and those have been placed in the department seniority list, they have been placed above the petitioners, and now in the status of the petitioners in the seniority list, Lordship, page 33. Now they have just shown it as engagement. There is no temporary, there is no contract or whatever, and they have shown us our status in the seniority list of staff nurses as engagement. Those who were appointed in December, their status is shown as, their condition is, service condition is shown as temporary, whereas we, those who were recruited through advertisement as per law, we are shown is engagement. So
All
what
right,
is an
all right,
engagement?
we'll take it up again some other day. You get your instructions regarding when exactly did you resign? Petitioner.
Lordship,
Petitioner said,
whether prior or after, I shall make
find
the
out.
clarification, Lordship.
More or
I
less-
also have Supreme Court cases.
Surely,
with me.
more or less, I think picture is materializing now.
Yes, Lordship.
We can have it on Thursday, maybe?
I will, yes, I have, I'll submit my citations, Lordship, on Thursday. I have citations.
Please call the steno.
Lordship, Thursday, I have VC at the principal bench
Okay, so when should we have it?
Sooner the better, Lordship. But Thursday on 8, I have a fixed matter.
Huh? 9?
Yes,
9th is what?
9 is Friday.
Can we continue tomorrow otherwise?
We shall do that, we shall do that. I
Let's
am
have it
obliged,
tomorrow.
Lordship.
Let's have it tomorrow.
Lordship.
This is the matter again tomorrow for admission. That's great.
For admission,
Obliged.
Obliged, Lord.
item number 14.
Yes.
May I place your lordship? This matter is also little similar to the present case because there are 9 petitioners. The petitioners are medical officers. They were initially appointed on contract and all of them have completed crossed more than 10 years by now. But what happened was, just before coming to the brief, I'll just summarize. What happened was, there are 2 office memorandums issued by the government for consideration of regularization. Who have completed 10 years, direct regularization, who have completed 5 to 10 years, then screening test will be conducted. The petitioners, they face the selection process by so as to regularize their service in terms of the office memorandum. And screening test was conducted and they were qualified. But then the state respondents have not acted upon. Although everything was done, only the formal order was yet to be regularized. It so happened that some cases were filed by the account and organization challenging the office memorandum. That was stayed for the time being, and it so happened that their cases were taken up by during that time when that order was stayed, the office memorandum was stayed. But ultimately, the writ petition was dismissed. Therefore, the interim orders were merged with the final order. So automatically, the interim order stands vacated. But then after vacating the interim order, the state respondent did not acted upon. No formal order was issued. So the petitioners approached this honorable court for issuing a direction to the respondents to act upon the screening test for regularization of their service. As luck would have it, it so happened, Lordship is well aware, in 2020, in the month of March, the world was hit by COVID-19 pandemic. So the health sector, the health workers were required urgently also. And Lordship is well aware, during that time, many healthcare workers, they have resigned who are on voluntary, contract or a talk, who are in temporary basis. Many of them, they have resigned from the post also. And Lordship has just gone through the other office memorandum that the circular issued by the government, the one-time special relaxation, will not be applied to those who have resigned during the COVID-19 pandemic. Even they were excluded, who did not have the courage to work. That policy will not be applied to those persons who have resigned. To that extent, the relaxation was given. So by sacrificing our life, we have rendered service during this COVID. So the government has formulated a policy to regularize our services. So in the same office memorandum on 11th of June 2020, a decision was taken by the cabinet to regularize 19 medical officers. Post was created before that on 7th of June 2020. the cabinet has created the post in various categories. And then the petitioners, who are 9 in numbers, a decision was taken to regularize 19 doctors. Along with that, few doctors were appointed during the COVID for 1 year. 27 doctors were appointed for a period of 1 month, 1 year. And it so happened that cabinet has taken a decision to regularize those persons also. Therefore, the NHM doctors, National Health Mission doctors, they have lodged a complaint to the state government saying that, look, those persons who are appointed only for a period of 1 year, that is pertaining to 27 doctors, a complaint was lodged. So cabinet had to sit again and review the decision they have taken to regularize our service, as well as 27 doctors, medical officers. And in fact, the NHM doctors' complaint was only with regard to the 27 doctors. Government took advantage to cancel all the 19 doctors, which includes us also. And in this petition, we are challenging the cancellation of our regularization. Our regularization was cancelled by an order dated 23rd June 2020. So our regularization was alive only for about 12 days. And we are questioning that the cancellation order on the ground that, look, the cabinet decision has been cancelled on the basis of a complaint lodged by the National Health Mission doctors, which was pertaining to only 27 doctors, not us. What happened, Lordship? Among the 19 doctors, we are a group who has already crossed 10 years of our continuous service in the department on contract. But it so happened that few doctors who were having less number of years, but they were also included. So if those doctors are regularized, then few of the doctors who are working on the NHM will be superseded again. Maybe that is the reason why they have clubbed together along with the 27 doctors, and then cancellation order was issued by the cabinet. We are questioning that, look, what is the basis of cancelling our regularization order? What is the basis? Give us the reason. Why? During the pandemic, you have invited us and then persuaded us to remain in the service so as to regularize, under pretext that, yes, we will regularize you. And we were regularized. After 12 days, they have canceled. Just on the ground and basing on the complaint lodged by the NHM doctors, which complaint was pertaining only to 27 doctors. Now, by filing counter affidavit, government has again taken a U-turn and then trying to twist the matter by relying on the Omar-DB's case. And then this is not in terms of the service role. Lordship has just seen on the other case, the service role was relaxed as a one-time special measure by the government during this pandemic, so as to fight the COVID-19 pandemic. That was done. And now they are saying that no, recruitment can be done only through as per the provisions of the service role. By ignoring, so they are, on one hand, they are appropriating, on the other hand, they are appropriating, which cannot be done. So that is the basic issue involved in this case, Lordship. Screening test was conducted. We were qualified, all of us were qualified, and there was an order by the court to consider our case for regularization. And thereafter, COVID pandemic came. During that time, a policy decision was taken, and then we were regularized without any justification, without any basis, basing on an irrelevant ground. Our regularization has been cancelled by the cabinet on 23rd June 2020. That is how we are before this honorable court, Lordship. To start with a detailed hearing, my lord, I do not know whether today Lordship would like to take up, otherwise I am ready to make my submissions, Lordship.
No, it's all up to you all. If you want to start, you can start. There's no issue.
Then let me refer to the documents, Lordship, one by one. It will not take much time. Page 17, Lordship, Annexure A, because I would like to start from our appointment.
Yes.
Annexure A, page 17. This is the appointment orders. There are 9 persons, but only 5 persons are petitioners here. Serial number 2 is petitioner number 3. Serial number 3 is petitioner number 2. Serial number 6, that is petitioner number 1. Serial number 7, that is petitioner number 4. Serial number 8, that is petitioner number 5. They were appointed as medical officer, class 1 cadet. And then next page, Annexure B, page 18. Serial number 2 is petitioner number 8. This is 18 May 2013. And Annexure C, page 19. Serial number 1 is petitioner number 9. Serial number 3 is petitioner number 6. And serial number 7 is petitioner number 7. So these are the appointment orders. It is 18 May 2030. So all of them have crossed 10 years and above now. Now, page 20, Annexure T. But the type copy is more clear, which Lordship will find at page 21. This is order dated 4th September 2017. May I read, Lordship?
Yes.
In pursuance of the Clean Air Department AR branch memo number so-and-so dated 4/8/2008, the Governor of Nagaland is pleased to constitute a committee consisting of the following members to conduct a suitability test for regularization of contract service in respect of 11 contract doctors under Health and Family Welfare. And then the officials are shown. And then last paragraph, the committee will hold a suitability test for contract doctors who have fulfilled the criteria as per the above mentioned memo number 69/2017 at 11 hours in the Directorate of Health and Family Welfare. All members are requested to attend the meeting without fail. This is issued on 4th September. Out of these 11 doctors, 1 resigned and 1 expired. I will show that later on. And then suitability was conducted. And Lordship, may kindly come to page 23. This is 6 September 2017. This is the minutes of the meeting of the suitability test conducted by the board for regularization of the petitioners. And the list of marks, Lordship will find at page 27. Page 27 is the marks secured by the petitioners. Out of these 11 doctors are shown here, page 27, Lordship. Suitability test for regularization of 11 contract doctors Here marks is given. Serial number 6 has resigned. Dr. Cho Chang Shilu, MChin, medical officer. Serial number 6 has resigned. And serial number 10, Dr. Kisoloto Tetsu, he is unfortunately expired. Lordship. So now there are 9 doctors out of this 11 who faced the suitability test. And then marks are given. Can we come to page 34? Suitability test was submitted to the Secretary PNR Department. May I read this order, Lord?
Yes.
Subject, submission of meeting minutes along with the scoring sheet obtained in suitability test by 11 contract doctors for regularization of their contract services regarding. Madam, I am directed to refer to the subjects headed above and to forward herewith 5 sheets of the minutes of the meeting of suitability test conducted by the board on 6/9/2017 as per the PNR Office Memorandum number so and so dated 4/8/2008 along with all relevant papers for consideration regularization of contract service in respect of 11 contract doctors who have put in 3 years or more of service under Health and Family Welfare Department for your information and onward submission to the screening committee for further necessary action. And then next page is the memorandum, page 35, Annexure G. This is a memorandum dated 17 October 2017. This is also the forwarding of minutes of the screening committee meeting held on 13th of October 2017 for follow-up action by the department concerned. The undersigned is directed to forward herewith an extra copy of the minutes of the screening committee meeting held on 13/10/2017 as reproduced below. Serial number 10, Health and Family Welfare regularization of contract services of 11 doctors. The committee recommended regularization of the contract services of 11 doctors in respect of Dr. So-and-so, so-and-so. As I have pointed out to your lordship, serial number 6 has resigned and serial number 10, that is Roman 10, is expired. Now the certificate, the committee was instructed that all subsequent vacancies were being requisitioned to NPSC, the other vacancies. Now, Lordship may like to know what is the policy. I believe Lordship has also came across about this policy, page 36. This is the memorandum dated 4th August 2008. This is the policy for regularization. First group is the employees having more than 10 years of service. And the second category is employees having 5 years to 10 years of service. This has been categorized. This is the policy for regularization of the contract employees who have been appointed on contract. Relevant paragraphs which will be relevant for our purpose will be paragraph 2, Roman 6. Because at the time of conducting the suitability test, we are coming under this category, Lordship. Serial number 2, Roman 6.
Yes.
May I read, Lordship?
Yes.
I am reading Roman 6. The performance of the employee has been satisfactory in the service. An examination written and viva voce to test your suitability should be conducted by the concerned departments under the chairmanship of the head of administrative department with representative from the PNR department and ATI, that is Administrative Training Institute, Nagaland, Kohima. Qualifying marks should be laid down in advance and only those who qualify such as screening test should be considered for regularization by following the procedure as mentioned in the para 1 above. So paragraph 1 is the top paragraph. And the next office memorandum is dated, the office memorandum dated 11 August 2016. page 37, annexure I. This is issued by the Pioneer Department, Administrative Reforms Branch. Here, on the subject, Lordship will find ban on appointments on contract basis. And this memorandum also says about the regularization on completion of 3 years in terms of OM 4/8/2008. This is the first office memorandum which I have been referring to, Lordship. By this order, office memorandum, the government has passed an order banning all the contract appointments. But if persons who have completed 3 years of continuous service should be regularized, but henceforth there can be no appointment. So this will be important for us. Ban on appointment on contract basis. Following the ban on appointments on contract basis in both White Department's OM of event number dated 6 June 2016, the matter has been reviewed and it has been decided that the existing ban on contract and ad hoc appointments shall continue and all appointments should be done only by following the prescribed procedure. It has been further decided that the departments shall estimate the number of vacancies likely to arise during the next 1 year on account of retirement, promotion, etc., and place requisition for filling up such vacancies to the Nagaland Public Service Commission to enable timely retirement, having in view the ban of appointment on contract basis and need to clear earlier cases pending for regularization. It has also been decided, this will be important, this portion, decided that the cases of government employees appointed on contract basis prior to the ban notified White Pioneer Office Memorandum dated 6/6/2016 shall be taken up for regularization on completion of 3 years of continuous service on contract ad hoc basis in terms of OM number so-and-so dated 4/8/2008 and in supersession of Office Memorandum of 2010-2015. This has the approval of the Cabinet White Memorandum dated July 2016. So this is the office memorandum by which the contract appointment, fresh appointment has been banned, and at the same time, the governments have been directed to consider take up the cases for regularization who has completed continuous years of 3 years. So in spite of this office memorandum, the cases of the petitioners have not been considered. That is why they were compelled to approach this honorable court by way of filing a writ petition, seeking a direction to the state respondents to consider their cases. And by an order dated 14/9/2018, this honorable court was pleased to issue a direction. Background is given, but may I just turn to the relevant portion, Lordship?
Yes.
To save time. Let me refer to 2 paragraphs, Lordship, at page 39. Third paragraph, Mr. C.T. Chamir, Learned Senior Counsel. That's your Lordship, correct?
Yes.
Mr. C.T. Chamir, Learned Senior Counsel, appearing for the petitioner, submits that as WPC number 145K of 2017 was dismissed as not being maintainable and not on merits, any observation made by this court on the merits of the case would have no bearing in the matter. Further, this case is regarding the challenge by the account, one social organization, NGO, challenging the government memorandum also, but then that was dismissed. Oh, he was referring to the further. He contends that even if the observation made in the judgment and order dated 3/8/2018 is considered, the state observation categorically states that the state respondents have been directed not to regularize any person if he has completed only 3 years on contract ad hoc in terms of Office Memorandum 11/8/2016 and OM dated 4/8/2008. It is submitted that the petitioners in the present case has already served for more than 5 years and above, and therefore any observation made by this court in WPC number 145K of 2017 does not affect, this should be affect the case of the petitioners. That being the position, the petitioners had made a representation before the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima, on 21/8/2018, praying for regularization of their services in terms of the process that had been initiated prior to the interim order that was passed on 28/7/2017. By the said representation, the judgment and order dated 3/8/2018 was also brought to the notice of the respondents. However, despite making the representation dated 21/8/2018, the respondents are yet to take any further steps in the matter. After hearing the learned counsel for the parties and on consideration of the materials available and records, this writ petition is disposed of at the motion stage, directing the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima, that is respondent number 2, to consider the representation dated 21/8/2018 made by the petitioners and dispose of the same by a speaking order in consonance with the OM dated 4/8/2008. Let such exercise be completed within a period of 3 months from the date of receipt of the certified copy of the order by the respondent number 2. Till the consideration is made by the respondents, the possession of the petitioner should not be disturbed. With the above observation and direction, this writ petition is disposed of. They have accepted this judgment also, but then no formal order has been issued. Now we are coming to the most crucial and the important document by which our cases have been regularized and which was cancelled thereafter, which is the ambient order here. So I'm referring to Annexure K, page 41, the memorandum dated 12 June 2020. Although it is shown as 12 June 2020, the cabinet has held a meeting on 11 June 2020. So in several correspondence, it was shown as 12 June 2020, but in fact, the cabinet has taken the decision on 11 June 2020, Lordship. So here also, all are not relevant for us. I would like to refer only to the background and where we are concerned with, because so many posts were created during the COVID-19 pandemic, and I will just take your Lordship's attention only to the relevant portion. I believe this was also read out in the earlier case also. Anyway, may I read, Lordship, the relevant portions? Yes. Let me start with agenda number 1, page 41. Appointment of doctors and nurses under Health and Family Welfare. The cabinet considered the proposal of the Health and Family Welfare Department and deliberated in detail in the backdrop of COVID-19 pandemic. The department explained that there is severe shortage of doctors and nurses in comparison with IPHS norms, Indian Public Health Services norms, which is 23% as against 50% in case of specialized doctors and 28% as against 75% in cases of staff nurses as per the IPHS norms, and that the department was unable to provide required number of doctors in the districts. Further, in view of the large number of positive cases being reported in many districts, deployment of additional doctors and nurses is required for containment and treatment facilities. In view of this will be very important, Lordship. In view of the prevailing extraordinary situation, the cabinet, having considered the views of the PNER department, including related Honorable High Court judgment dated 3/8/2018 and order dated 7/2/2019, and the financial implications, reviewed the urgent requirement and decided to approve the proposal of the Health and Family Welfare Department as follows. The two dates which are referred to, I will refer. These are all given in the common affidavit, Lordship, as follows. And then paragraph 7 will be relevant for us. page 42, para 7. Regularization of 19 serving contract medical officers under the Health and Family Welfare Department. And then 8 is also relevant, although it is not pertaining to us, but this has a relevance. Regularization of 27 existing medical officers who were engaged by the department for a period of 1 year. So here, I would like to make a distinction here, Lordship, because this will be very pertinent and relevant. The petitioners, that is, which are shown in serial number 7, 19 serving contract medical petitioners are included in this category. And paragraph 8, 27 doctors. These are the doctors who are appointed during COVID-19 pandemic for a period of 1 year. And Lordship is well aware, so many abnormal situations happened during that time. Now that the situation is normalized, we have forgotten everything. What was the situation then? But my humble prayer is, look, we should not undermine and forget and overlook. What was the situation when the decision was taken? Considering what background they have taken the decision, that will be very, very relevant. Because during the COVID-19 pandemic, Lordship is well aware that so many abnormal decisions were required to be taken. So we have to keep that in mind. Now, what I'm trying to highlight here is serial number 7 and 8 at page 42. It talks about 2 categories of doctors, and the petitioners belongs to 19 doctors, that is serial number 7. And NHM doctors have lodged a complaint that is pertaining to 27 doctors. May I read paragraph 10?
Yes.
And the last paragraph. The Health and Family Welfare Department should inform the Honorable High Court in view of the judgment dated 3/8/2018 and the order dated 7/2/2019 passed in connection with regularization of government employees. The Cabinet further directed that this approval is in one-time relaxation of laid-down rules and procedures for recruitment, regularization, and continuation of age. Further, this one-time measure in view of prevailing situation in the backdrop of COVID-19 pandemic shall not be treated as a precedent. Under these circumstances, with these clear conditions, the government has taken the decision. Court was very much aware about the orders passed by this honorable court. The government. The government was very well aware about the rules, procedures prescribed for appointment and recruitment. They were aware. But then in order to contain the COVID-19 pandemic, they have taken this extraordinary decision, and this is not to let down as a precedent, but one-time special measure which cannot be taken as a precedent. Very clear logic in the mind of the government. They were very conscious about all the barriers, but then they had to take a decision. That is how the Cabinet has taken the decision on 11th of June 2020 to regularize our services. Now, I believe before the deadline, I can complete the documents. So the ambient order, page 43.
That's okay. We need not be in a hurry. We can always continue.
See, kindly, Lordship, may kindly see. This is 15 June 2020.
Yes.
The memorandum, Cabinet Secretariat, Cabinet Seal. Minutes of the Cabinet meeting held on 15 June 2020. The undersigned is directed to forward herewith an extract of the minutes of the Cabinet meeting held on 15 June 2020 for kind information and necessary action. agenda number 1. Appointment of doctors and regularization of services appointed under NHM, NHK, and SSCS in the Health and Family Welfare Department. Serial number 1. The cabinet in its emergency meeting, discussed the proposed adjudication of the National Health Mission employees against the regularization of 27 doctors who were appointed for 1 year under Health and Family Welfare Department and subsequently regularized by the cabinet in its meeting held on 11 June 2020. And others are not relevant for us, but clause 4 is relevant. The cabinet directed that this approval is a one-time relaxation of laid down rules and procedures for recruitment, regularization, and continuation of age. Further, this one-time measure in view of prevailing situation due to the COVID-19 pandemic shall not be treated as a precedent. And then the 5th one, Health and Family Welfare Department should inform the Honorable Court in view of the judgment dated 3/8/2018 and the order dated 7/2/2019 passed in connection with the regularization of government employees. Now, what are the 2 orders which are mentioned here? Before coming to this, I would like to emphasize in agenda 1, clause 1. Lordship has seen, and it is clearly mentioned in the decision that this decision of 15 June 2020 has been taken basing on the adjudication of the National Health Mission employees against the regularization of 27 doctors who were appointed for 1 year under Health and Family Welfare Department and subsequently regularized by the cabinet in its meeting held on 11 June 2020. So this decision was taken because of the complaint by few NHM doctors against 27 doctors only. Therefore, they were compelled to take a decision because of regularization of 27 doctors who were appointed during the COVID time for a period of 1 year only. Therefore, this should not be applied to us, number 1. Another aspect which Lordship may like to know will be paragraph 5. Here, 2 judgments, department, the cabinet has taken a decision directing the Health and Family Welfare Department to inform the Honorable Court in view of the judgment of the 2 orders, 3/8/2018 and the order dated 7/2/2019. What are these orders? First order of 3/8/2018 is an order passed in WPC number 145K of 2017 filed by the account. And in that judgment, this Honorable Court has passed an order that state shall not regularize any person who has put only 3 years of service in contract and a talk in terms of the 2 OM, that is 4/8/2006 and 11/8/2016. So it doesn't speak about the doctors or employees who have served for more than 3 years. And Lordship has seen the office memorandum that yes, government has taken a decision to regularize the persons who have completed more than 3 years on 6/6/2016, because that is the date when the government has fixed the date pending the fresh appointment. So persons who have been appointed prior to that and who has completed 3 years on 6/6/2016, they should be taken up for regularization. That was the case, and in view of that policy decision, the regularization orders have been passed, but ultimately, this Honorable Court has passed an order that State cannot regularize basing on the two OMs who have completed only 3 years of continuous service. Therefore, since the petitioners have completed more than 3 years, even more than 5 years, it is not touching their case, which was also challenged by the government, and the government appeal was dismissed, and the order passed by learned single judge has been upheld, Lordship. That means persons who have put only 3 years of continuous service cannot be regularized. But it doesn't say about the persons who have put into more than 3 years of continuous service. So the petitioners are included among the doctors, among the employees who have crossed already minimum 3 years of continuous service, Lordship. Now, the implement order, Lordship will find it page 44, annexure M.
No decision was taken by this 43, page 43.
43. They have discussed.
They've only
but then-
discussed.
Yes.
They have only discussed.
No
There's
final decision was taken.
No
So
decision taken.
on 25th June, 23rd June, they have taken the decision. Lordship will find it annexure M, page 44. May I read, Lordship?
Yes.
This is 23rd June. In many correspondence, it is referred as 25th June, whereas the decision was taken by the cabinet on 23rd June. Minutes of the cabinet meeting held on 23rd June 2020. The undersigned is directed to forward herewith an extract of the minutes of the cabinet meeting held on 23 June 2020 for kind information and necessary action. Agenda number 1. Recruitment of doctors, nurses, and other paramedical staff in the Health and Family Welfare Department. The Health and Family Welfare Department submitted a comprehensive proposal for creation of posts. The department presented the manpower status indicating existing regular and contractual manpower as compared to the norms of Indian public health standards. The cabinet deliberated the matter at length, and in the backdrop of unprecedented situation arising out of COVID-19 pandemic and the need to address the inadequacies of the state health system, including shortage of manpower at requisite levels. After detailed deliberations, the cabinet approved creation of the following post in the Department of Health and Family Welfare. And then finally come to next page, page 45, clause F. We are concerned with this. And before that, on the top, Lordship will find the cabinet further directed that will be relevant, and we are concerned with F. The earlier decision of the cabinet to regularize the services of existing contractual employees and new appointees stands revoked in view of the legal opinion. So this is the basis how they have canceled our regularization. Now, Lordship, we can see page 42. Serial number 7 and 8. These are cancelled by this impugn order, Lordship. This is the impugn order. And the complaint by the NHM doctors is in respect of 27 doctors, and there is no grievance at all against regularization of 19 doctors, because Lordship will find the cabinet decision at page 43. Agenda 1, clause 1. Because of this they were compelled to take this decision of 23rd June 2020.
What is the legal opinion referred to here? Anything on the records? Legal opinion.
In my opinion, Lordship, legal opinion was sought during the pendency of those cases.
Those two cases.
Yes. So, since it was not finally decided, the opinion was rendered, may have been rendered, that no, in view of Omar Dibi's case, you cannot regularize. Possibly, those are the opinion given. But then the cabinet was very conscious about their decision that we have to inform to the Honorable Court. Government has not taken any decision, steps to inform this Honorable Court because that time there was no case pending. No case was pending. Case, writ petition disposed of, interim order also vacated. That means two office memorandums are still alive even today. And no courts, either in the writ court and the appellate court, these two office memorandum on the basis of which the regularization order was passed has not been quashed. Only after filing the writ petition, government has taken a U-turn just in order to come to the case. That no, it is contrary to the service law. But this is against your own decision. Number one. Secondly, even going by the orders passed by this Honorable Court, in paragraph 29 in the writ petition, in the judgment, it was categorically mentioned that I have just referred to, state respondent shall not regularize those who have completed only 3 years of continuous service basing on the two OMs. It doesn't say about the persons who have served for more than 3 years. That means this Honorable Court has affirmed the decision of the government to consider the cases for regularization of the employees who have served for more than 3 years. And that order of the learned single judge has been upheld by the division bench also. So the principle also today is that, yes, there was a finding and direction by this Honorable Court not to regularize those persons who have completed only 3 years of continuous service. But the petitioners are not coming under that. So they are outside the review of that observation also, even assuming that that should be applied. Therefore, our regularization order has been cancelled by the government without any justification. Rather, a decision was taken just because an agitation was held by the NHM doctors against the regularization of 27 doctors who were appointed during the COVID-19 pandemic for a period of 1 year only. Therefore, Lordship, the action of the state respondent is liable to be interfered with, and the imbued order is liable to be quashed. It is like you just hire and then fire. Now that the situation is already over, nothing doing, you go. But then we have sacrificed our life during the COVID-19 pandemic. Many employees have resigned and quit the job, and they have abandoned the post and left. And the department is admitting that fact. They will definitely admit what was the situation by then. For sacrificing our life and serving the government, this is the remuneration we are getting.
Where is the regularization order? Was it passed?
No formal order has been issued. Only a policy decision was taken to regularize our services.
You are challenging the decision.
Yes.
One decision says that regularize, other decision says cancel.
Revoke. So what is the basis? So the basis is that at page 43. Agenda number 1, clause 1. That was the basis.
There is no such formal order passed otherwise, isn't it?
No.
Only the cabinet decision was taken.
Yes.
And it
Yes.
was later on uh, revoked.
Yes.
And the other two annexures are basically your extension of your service.
Extension, yes.
For 1 year.
Yes. It is extended up to 31st March 2024. The last page is the last extension order. And serial number 10 is not a petitioner. Otherwise, 1 to 9 are all petitioners here.
You all work under the State Health and Family Welfare Department.
Correct, Lord Chief.
And there were others who were working under the NHM.
Yes, who has lodged complaint. And the 27 doctors are the doctors who are appointed during the COVID-19 pandemic for a period of 1 year. They were also made to be regularized with us. Although no formal order was issued, a decision was taken to regularize those 27 doctors. And NHM doctors are against this. So if they are against this, the cabinet should have taken a decision about this only. When no complaint was made against us, what is the necessity to include our case also to revoke?
Okay, we'll continue tomorrow.
Lord Chief. And the government has filed counter, as I have submitted earlier. They have taken 2-3 points basically. They are bringing on the OMADB's case, but the cabinet decision was taken when OMADB was there. And OMADB could not control the COVID-19 pandemic when it was, when the entire world was hit. Therefore, the decision is an exceptional decision taken during the extraordinary situation of COVID-19 pandemic.
This is the matter again tomorrow. That's part of.
Lord Chief, regular list may have already published, so let it be listed in the supplementary list as a part third matter, Lord Chief.
This is the matter again tomorrow as part third in the supplementary list. Now, similarly, I think that one case, that earlier case, 11, this also should be reflected as part third, okay? So that we can give some priority to this. We'll take up the 11 as part third first, then we'll continue with this tomorrow.
Hopefully my learned friends will conclude the matter early.
I hope so.
For orders,
Much obliged.
item number 24.
Steps have been taken, Your Lordship.
We'll
Service is
list-
still awaited. Your Lordship.
We'll list again after 2 weeks.
Lordship.
List the matter again after 2 weeks to await service report from respondent number 7.
For orders, item number 25.
Similar order, only thing is that will be respondent number 6 instead, okay?
Interim order, Your Lordship.
Interim order is
Interim
there.
may be continued, Your Lordship.
Interim order passed earlier to continue till the next date. Any other item? That's all, huh?
Obliged.
Obliged.
That will be interim will be item number 25. This one. Yeah, yeah.